lords, we had circulated a note, my lords, last week and 3 compilations. And we have, my lords, circulated 1 additional compilation yesterday, my lords, yesterday evening. Additionally, my lords, I will also be referring to note 2 of the learned SG, my lords, because the aspect with regard to child.
Yes.
And my lords, at the outset, I must also say, my lords, that though the application is filed on behalf of NCPCR, but we had to take lots of inputs from the Ministry of Women and Child Development and also CARA. So Lordship may take it that these submissions are, my lords, comprehensively from these 3 bodies, my lords.
Which submissions you will be referring?
My lords, we filed our submit. I made
Yes,
a brief.
we have your list of.
Lordships
you
have
a
my
written
submissions, my lords. It is in 3 parts, my lords. Part A, Part B, and Part C. I can actually confine only to Part B because other aspects are which are covered, but that's just for the sake of completion, my lords. It's a short note. And there are 3 compilations, my lords, A, B, C, and 1 filed yesterday, D.
So we have now a master index by Ms. Bhatti.
Please, my lords.
Then we have Part A compilation, Part B compilation, Part C, and Part D compilation.
Please,
then
my
your
lords.
written submissions.
Please, my lords.
That's the...
Lordships, please. My lords, Part A of my note is, my lords, where I'll just give a brief. Wherever your lordships want me to stop and elaborate, I will. Yes. I'll just give an outline, my lords. So the first Part A really deals with 2 submissions, my lords. First, I have tried to submit that there's a basic structure of the marriage, and that is a union of man and woman. The second submission I have, my lords, is gender fluidity. I'm not elaborating, my lords. I'm just stating my propositions. And the second submission I have is that gender fluidity is impermissible where cisgender is core. And ignoring rationale of valid classification amounts to perpetuating inequality. Then I've given examples of areas which have been reserved specifically for women. Because if these spaces are diluted in any manner, then what will be lost is really the cause of women's equality, women's well-being, women's empowerment. That is my second point, my lords. And I've given examples like women's recruitments, spaces which are specifically for women, women's washrooms, women's correctional homes, women inmates, welfare homes, ladies' barroom in the Supreme Court. When your lordships recognized in NALSA transgenders as a third gender, your lordships did not, using the expression that Mr. Datar did, my lords, did not retrofit in the 2 existing genders. Your lordships identified them as a third gender. So, my lords, it's very critical that gender fluidity cannot be permitted in areas where cisgender is core. That brings me, my lords, now to Part B. That is specifically with regard to children. And my lords, the preposition that I have is welfare of child is paramount and sacrosanct and cannot be opened, exposed even for an iota of potential compromise or uncertainty. My lords, for the first preposition, that is the child has a right to be born and raised by biological parents. My lords, for this I will rely on note 2 of the Learned Solicitor General for India, my lords. Your lordships will kindly have page 39 to 49 of that note. There are some research papers also which is there in their compilation, but Learned SG's note quotes the paragraphs that are relevant. If your lordships will kindly take that with me, my lords, page 39 of note 2 of Learned SG. Only for the purpose of these 2 prepositions, that the legitimate state interest of ideal mode of child rearing. My lords, all children are naturally born only to heterosexual couples. And now, my lords, when I take your lordships through the architecture of my lords laws which are relating to children, there are no competing rights in this space, my lords. The only sacrosanct, paramount right is that of the child. To the extent that sometimes a child may need to be protected from himself. The entire, my lords, architecture of these laws are from the concept of welfare of child being paramount. So, my lords, my respectful submission is, if your lordships will, my lords, have page 39 of Learned SG's note, my lords.
Which note?
Note 2, my lords.
Note 2.
Note 2 of the Learned SG. This chapter, my lords, the
violation 2. Note 2.
Note 2.
PDF page 39.
My lords, it's running 39. PDF should be
PDF of 44.
44. It could be, my lords. 42. I'm grateful. 42, my lords.
42.
The legitimate state interest of ideal mode of child rearing. Am I,
Yes.
my lords?
Page 42 starts with Note 2, Fundamental Rights, para 59.
My lords, this is para 63.
63. Very well.
Bottom.
Got it.
Yes.
My lords will see, my lords, this is for the preposition that legitimate state interest of ideal mode of child rearing. Now, lordships will, my lords, the fundamental point is that a child can only be naturally born through a heterosexual couple. And therefore, the special significance of recognition of heterosexual marriages cannot be understated from the point of view of child, birth of child and bringing up of the child, both. My lords, there are some very interesting papers that have been put together, my lords, in the research of this note. And my lords, these papers show that fathers and mothers both play complementary roles in upbringing of the child. And state is justified in treating homosexual and heterosexual unions differently for that purpose. The first paper, my lords, that is quoted in para 66 is straight is better while law and society may legitimately prefer heterosexuality, is a paper, my lords, from a professor of law, my lords, of Case Western University, Ohio. Your lordships will find that at page 353. The entire paper is there in compilation, volume 8 of Learned SG, my lords. It's mentioned here. The relevant paras are quoted here. And if I can draw your lordships to the last para that is quoted at the next page, my lords.
Which page?
Marriage, my lords, I am at page 41, the noted page 41.
Yes, but which compilation?
Same thing.
Note
Same
2.
thing.
OS.
Learned SG's note, my lords. I was just giving that the complete paper is there, but the relevant portions are here. So, marriage is not a factory for childbearing. Marriage exists to encourage men and women to create the next generation in the right contexts, and simultaneously to discourage the creation of children in other contexts out of wedlock in fatherless homes. Well, that's the next paper that's in para 68 is marriage from a child's perspective. How does family structure affect children and what we can do about it? Please see the highlighted portion. It is not simply the presence of two parents, as some have assumed, but the presence of two biological parents that seem to support child development. Children in single-parent families, children born to unmarried mothers, children in step families or cohabiting relationships face higher risk of poor outcomes than do children in intact families headed by two biological parents. Parental divorce is also linked to a range of poorer academic and behavioral outcomes. The next paper, my lords, this is my lords, Pennsylvania University law professor. The next paper is Tradition, Pluralism and Same-Sex Marriages. This has 4 authors, my lords. The paper your lordships will find in volume 8 of the Learned SG's compilation. Please see, my lords, the highlighted portions in the second para. To date, the research on child well-being and family form bears out that children thrive on structure, order, routine, stability, continuity, certainty, and clarity. The evidence shows that conventional beats unconventional every time. This means that complexities and ambiguities of non-traditional families come at a price.
But Ms. Bhatti, our law permits a single person to adopt a child.
My lords, permit me to come to that now.
Yes.
Your lordships will see this, my lords. The Learned SG did not place it. Lordship may note that this is, my lords, from page 39 to 49 on both the prepositions. The first is, my lords, that the legitimate straight interest, and that I showed to your lordships, and that there are some papers, my lords, on there is lack of data to establish equivalence with biological heterogeneous upbringing of children. Lordship may see it. I just brought it to your lordship's notice because it was the Learned SG left it to me, my lords.
Right.
Now, please come back to my note, my lords. Your lordships will see.
Which is your note now?
My lords, your lordships had my note, welfare of child.
Yes.
I was.
1 second, yes.
I'm sorry. This.
To go back.
I've
written
opened so
submissions
many-
on behalf of.
Yeah.
So I've said only NCPCR, but it's also the ministry and Kara.
Written-
My lords will have para 8, my lords, at internal page 5, at page 5 of my submissions. This I have placed. The second proposition is,
I
Just
don't
a
know which
moment,
page,
just a
sorry.
moment, Ms. Bhati, we are
I'm
still
sorry, my
looking.
lords. Yes, my lords.
Right.
Para
This is
8.
para 5 at page 4.
No, but which note is?
This is the
Would
Ms.
not-
Bhatti's
You're
note.
talking of note
There's
two,
only
you
one
said.
note. Written
Yes,
sub-
my lords. Yes, my lords.
Gender fluidity, right?
Yes, my lords.
This-
That I just mentioned, and then I came to part B, which is
should
at page 5.
participate.
I hope my lords Justice Kaul have, my lords, the
Yes, I have it. That welfare of children is paramount and sacrosanct.
very grateful, my lords.
Click on Aishwarya Bhatti and you'll get.
8. My lords, I only touched the prepositions in part A because it has been extensively dealt with, and I am at, my lords, para 10 now, my lords.
Para 10.
State as parents patriae of children, my lords. And this is critical, my lords. I will show to your lordships the Juvenile Justice Act, because the entire architecture, when it comes to the legislations with regard to welfare of child, my lords, it's the child alone who has rights. And my lords, it's in sync with the UN Child Right Convention. It is in sync with the constitutional philosophy and ethos. And please see how the Juvenile Justice Act deals with. May I request your lordships to take my compilation A. I put the acts there so I can show.
Why don't we go through your written note? That
Please.
might be much better so that, we can get
Then your
a
lordship will
structure in our mind.
Wherever necessary, we will go there.
So, my lords, I'm not touching this aspect of parents patria any more than mentioning it that it's the
Absolutely.
settled.
Very well settled, so you don't have to
I've
read out the
put
case
some
law.
paras from your lordship's judgment. Then your lordships will see para 11, my lords. The architecture of child legislations is so pervasive and significant that it even extends to covering beneficially the mother of the child. My lords, human child, my lords, I don't have to state it, but human child really is one of the most helpless childs of all, my lords, living beings in the nature. And it needs all pervasive, intense and indulgent care in the early years. And therefore, my lords, mother has been strongly protected, not just in the Constitution, but also in the Juvenile Justice Act, the Maternity Benefit Act.
Yes.
My lords, Article 42, I have, my lords, adverted to in para 11. And my lords, para 12, I have stated that a gender may be fluid, but the idea of mother cannot be. And therefore, my lords, it is very pertinent and important that this is given a very careful consideration. The whole perspective is, my lords, that what I'm presenting for your lordship's kind consideration is from the point of view to show to your lordships that this architecture, how it is going to be, my lords, impacted by a declaration and reading into Special Marriage Act.
Against the situation, which is, forget about the gender part. There's sometimes only a father. who has
We
to
have
care
gone
for
beyond
the
motherhood. We have gone into parenthood today.
Yes, my lord.
Because there are, as Justice Kohli is mentioning,
Please, my lord.
there are single
parent,
parents.
Please, my lord.
Now,
male or a
there
female.
is a death at childbirth.
Please, my lord.
The mother unfortunately dies of disease or accident.
Please, my
The
lord.
compulsion.
And there is no question of the caregiver being the father,
Please,
regardless of. Likewise, there are adopted children
Children.
Yes,
of
my lord.
only, of males,
Please, my
by
lord.
men, by fathers. So it's gone beyond the concept of, in that sense,
I bow down.
when the Constitution envisioned it, and some of this parents patria, interestingly, if you see the quotation of Lord Justice Lindley, he talked about husbands, guardians, and fathers.
Please, my lord.
So that was a situation where women didn't have agency. Women were even seen as wards,
Please, my lord.
right? So therefore, the question of guardianship was that with men.
Please, my lord.
So it's an evolving,
I bow down, my lords. I bow down to what is falling from
what
your
is
lordships.
central to this, yes, is unchanging, which is the welfare of the child.
Please, my lords. So, my lords, my respectful submission would be, my lords, that your lordships may see it from the perspective that this method of naturally born heterosexual couples bringing up their children is the ideal mode. And the law and the entire regulation has provided for, my lords, children who do not have that. From that perspective, please see now, my lords, the aspect of adoption. I have given one example in para 13 of sponsorship, which is available to only widowed, divorced, or abandoned mothers to seek sponsorship for their children. That's a protection under Section 45, specifically available only to this category of women, my lords. Then please see, my lords, please see para 14. My respectful submission is adoption is not an alternate to biological birth, my lords. My respectful submission is that adoption is a mechanism to find
Equally,
best
our law
possible-
does recognize that you can adopt for a variety of reasons.
Yes.
You may adopt even though you are capable of biological birth.
Please, my lords.
You can adopt if you don't want biological birth.
Please, my lords.
There's no compulsion to have biological children. Therefore, our law does recognize
Please, my lords.
the fact that there may be situations within this ideal of, a cohabiting family with, father and mother of, of a heterosexual gender family having their own biologically born children. But that's not
Please.
how our law is postulated also, right? What happens if, suppose, between the pendency, during the tenure of a heterosexual marriage, one of the spouses dies, then the other spouse really assumes the character of a father and the mother, depending on, isn't it? So that is something which our law recognizes.
My lords, I bow down. The law recognizes again from the perspective of the child. Your lordships have held that there is no fundamental right of adoption.
No, I think we may differ on that, because even if you go back to tradition,
Yes, my lords.
the right of a grandfather to take in adoption
Please, my lords.
the son of the daughter, what is classically known as one of the approved forms of having a child,
Yes, my lords.
Pitrika Putra.
Please, my lords.
So that is a known notion. So it is not that this is no sanction. It is hallowed. It's hallowed in
My lords,
tradition.
I bow down, my lords.
Therefore, to say this is an exception may not be appropriate.
My
That
lords-
why did even in some schools, even grown women, widows are enabled to adopt? Why? There's another purpose there.
My lords,
And even there are situations where adoptions take place, and thereafter there is biological birth.
please.
That too happens. So
My
there are
lords.
any number of situations where adoptions is the norm.
My
But
lords.
yes, you're right. But then all this is serving to emphasize and heavily underline that there is a normal and these are exceptions.
My lords, my respectful submission is not of exception. My endeavor is to present to your lordships that all of this is crafted together from the perspective of child being at the core of it. It's
There's no
not
difference.
right that in yours.
Ms. Bhatti, that you need not labor at all. That
May
is-
not be. That may not be.
But the welfare of the child is paramount, obviously.
Definitely.
True.
So, my lords, adoption is, I want to show to your
But the
lordship.
means of realizing that welfare are numerous. The pathways are
I bow down.
numerous.
I bow down. In fact,
Some of
adoption.
them are a matter of choice, some are a matter of compulsion.
Function.
I bow down, my lords, and the Kara guidelines
But
actually.
tell us one thing, is it your case that a right which is otherwise available to an individual to adopt a child is taken away because that individual is in any relationship otherwise than a heterosexual marriage?
That is right, my lords. And that is not just true for adoption. That is true for assisted reproduction, which is now regulated by the assisted
So
reproduction.
if two people are in a live-in relationship,
Yes, my lords.
does that mean that therefore, because of the fact that the two people are in a live-in relationship,
Yes.
maybe a heterosexual couple, that they will not have a right to adopt?
Not under the existing law, my lords. Not just adopt,
But
my lords.
is the right of one of them to adopt taken away because she or he is in a live-in relationship?
My lords, one of them can adopt. But the only couple relationship that adoption
It's a heterosexual
and
relationship.
surrogate reproduction, all three of them only recognize one kind of couple. That is a heterosexual married couple.
Therefore, no. But therefore, if two people, if a
Yes.
heterosexual couple is in a live-in relationship, one of them can certainly adopt. Or is it Kara's case that we will deny you the right to adopt because you are in a heterosexual live-in relationship?
No, my lords. I permit me to show it to your lordships the Kara
If I
record.
may paraphrase your argument, it is
Yes, my
like
lord.
this. The public policy consideration which you are actually mooting or advocating, or rather stating, is that yes, we allow adoptions by single, let's say, males, single females, in their capacity as single males or single females.
Please, my lords.
But
not
the
when they're
moment
in a
they enter into
relationship.
either a
Union or
same-sex relationship or another kind of live-in relationship, that relationship is not per se recognized.
I bow down, my lords.
So the only recognition of a relationship of father and mother is where there is a
Heterosexual marriage.
Lordships, please. And that is true not just for adoption, but also ART Act.
My question is different. If people are in a live-in relationship,
Please, my lords.
then is the right of an individual in a live-in relationship to adopt taken away by virtue of the fact that they're in a live-in relationship?
My lords, they will not be, so only one parent can adopt as a
Fair
single
enough.
mother or the single
That we've got.
lordship.
But your circular says something to the contrary.
No,
Because your circular says that the moment you are in a live-in relationship, albeit in a same-sex relationship, then you cannot adopt even as a single individual.
my lords, I will quickly take your lordships through the architecture of the JJ Act.
Also,
Yes,
keep in
sure.
mind one more fact, Ms. Bhatti. Besides the fact that Honorable the CJ has pointed out,
Please, my lords.
there is that condition. And what if, and that what if will be important, that somebody per se says that he or she is not in a live-in relationship, you probably have a format or something that a person has to sign or say this for you to satisfy yourself, and subsequently does, then what happens? Will the child be taken back?
My lords, there is provision for disruption and dissolution in adoption also. There, my lords, it is carefully crafted because child who is adopted will become a child of that person for all purposes, for inheritance,
That's right.
for all other rights. So, my lords, it cannot allow this. There can be no uncertainty in, my lords, in these matters when it concerns.
Person, if he or she elect to adopt, will for the rest of their lives have to undertake that they will never be in a
No,
relationship.
my lords, there is no undertaking like that.
Unless it's a case of
No,
they're
my lords.
actually marrying.
No,
What
my
is
lords,
it that you're put?
There is no undertaking
What is
like
it that you are?
My lords, what I will tell your lordships how they are constructed is that a heterosexual married couple has to also have 2 years of stable relationship of marriage before they can adopt. It's not like they can, and they have to have consent from each other.
And if
It-
it's a single parent,
If it's a single parent, then there are other considerations. What is their age? What is the gender of the child? What is their gender? I want to quickly show to your lordships the architecture under the JJ Act, the Kara.
Show us that.
Lordships, Miss my lords, that compilation A, I have put all the 3 acts.
Sorry.
My lords.
Mr. Bhatti, what I can get what sister is saying is, suppose there is a single adoption.
Please, my lord.
There is an adoption by a single person. After a couple of years, child is being brought up by that parent and he decides, you can't guarantee the future what will happen. So he decides to have to begin with a live-in relationship. That's not a disqualification.
Not at all.
It will be there. So how do you explain this?
My lords, I will quickly take 5-10 minutes and take your lordships through the architecture, starting with the
Ms.
JJ Act.
Bhatti, we can recognize 2 points which you have made. One, if a couple wants to adopt a child, then our adoption regulatory regime only recognizes the right to adopt when you are in a heterosexual marital relationship.
Please, my lords.
All right? That's your first point.
Please.
We understand why and what the public policy underlying that is.
Please,
That if you have to be a couple, if you have to be a mother and father, you must be necessarily in a heterosexual marriage before you can both adopt a child as a couple.
Please.
That's your first proposition.
Lordships.
What we are asking you really is on something slightly different, which is nonetheless, our law recognizes the right of a single individual to adopt.
Yes, my lords.
And the question, therefore, is, and we take it that's your position also, that the right of a single individual to adopt is not affected by the relationship which that single individual may otherwise have, whether it's in the nature of a live-in relationship, which is heterosexual, or a live-in or a relationship of a same sex. So long as you are adopting, as a single individual.
Lordships, I bow down, my lords. That is my stated position. And my lords, your lordships will appreciate that because the law...
So we therefore take it that even a same-sex couple,
yes, my lord.
or let me rephrase it, an individual in a same-sex relationship
Please, my lords.
is not precluded from adopting a child. We
Please,
take
my
that as Kara's statement of position.
That is the mandate of Juvenile Justice Act. That is the mandate of...
If I may just make one more statement,
Lordship.
you will agree with. A single parent
Please, my lord.
who adopts remains a single parent, there is no difficulty. The moment she enters into a matrimonial relationship
Please, my lords.
with, it's a heterosexual relationship,
Please, my lords.
then the husband becomes the father,
Lordships.
correct? The adoptive father, like she's the
Lordship.
adoptive mother. So then the child, as a consequence, becomes the heir in the event of death to the properties of either,
Yes,
and rather both.
yes.
On the other hand, if the single parent enters into a sexual same-sex relationship, then the adoptive child continues to be the adoptive child of that adoptive father or the mother.
Please,
And no more, full stop.
Yes.
This is your proposition.
Lordships.
What you say is
So
that,
therefore,
it doesn't
sorry,
recognize-
just to take one thought further, what you're driving at here is the stability. Because even in the event of disruption of the family, like in the case of marriage, there is a divorce, the relationship of an adoptive child continues.
Lordships.
Whereas since there is no marriage and there is no marriage recognition, that stability would be undermined if you recognize.
I bow down, my lords. I bow down to your lordships. My lords, Justice Narasimha had a point.
Same. I was
My lords, in
looking
fact,
at
Kara has
your argument.
a fast-track method for step-parent adoption also. It may happen that somebody has a natural-born child and she becomes a divorcee or a widow and she remarries. So her child can be adopted.
Yes, by
There's a mechanism that is...
Obviously, yes.
My lords, it's very carefully crafted. My lords, we are a culture of my lords,
Perhaps-
Yashoda Mata and also Devki Mata, my lords. So both, my lords, one who gave birth and one who reared the child.
We will see those regulations. Perhaps there might not be anything formulated to say it's prohibited, but while hetero marriage might be recognized, same sex, the rules might not have provided any recognition. We will have a look at those rules.
Actually, my lords, that is why live-in is also not recognized, because live-in also is what Mr. Sybil was mentioning yesterday, the within, the concentric circles. The without is not recognized for live-in. Live-in are, my lords, now recognized under the Domestic Violence Act,
So a
120.
living couple cannot adopt a child as a couple.
Yes, because they can walk out
That's
of
fair
the
enough.
relationship anytime.
Fair enough. Then we understand what the public policy precept underlying it is.
Please, my lords.
But the existence of a live-in relationship does not prohibit one of the parties from seeking to adopt a child
Yes, my lords.
as an individual.
Yes, my lords.
So you're looking at it from the perspective of the child, which is that the
Lordships.
child is most benefited in every formation. At least there is one person responsible for that.
I bow down.
That stability is what you're actually driving at. And the
Lord-
core, at the
And
core
the
of
fact
adoption.
that one individual has adopted, that right to adopt or the continuance of that adoption is not affected by any subsequent change in the marital status of that individual who has adopted.
Please, my lords. Please, my lords. My lords, in fact, the ART and Surrogacy Act, the validity of some provisions are being considered by Court 5. There are a clutch of petitions that have challenged some provisions. And my lords, there was a point that was sent to the National Board for reconsideration. There's a very, my lords, well-equipped national board under ART and Surrogacy, because they are also, my lords, in a manner only recognizing this couple of heterosexual married couple as a relationship. And my lords, single women are allowed under the ART. And only widow and divorced women are allowed under
Then, Ms.
surrogacy.
Bhatti, can we then summarize your submission in the following terms? That just as there is no recognition, according to you today, in the state of our law, of a same-sex marital relationship, which is legislatively recognized, parallelly, there is no recognition in our law today of the right of a same-sex couple to adopt a child as a couple.
Lordships. Yes, my lords. I bow down, my lords.
And that is based on the foundation that a child must have a stable family existence, and which you postulate would exist in the case of a heterosexual marriage.
My lords, would your lordships just make a note of the sections that I am, my lord,
Yes.
giving to your lordships? The Juvenile Justice Act, my lords, I wanted to show to your lordships, it is at page 82 of my compilation A. I wanted to show chapter 8 to your lordships. And before that, I wanted to show some definitions and some general principles which are in section 2 and section 3. My lords, those general principles are very, very critical, my lords, from my perspective, because that is really an
Provisions you want us to see?
My lords, I want to draw your lordship's attention to some definitions in section 2 and general principles in section 3, my lords.
Which are the definitions section 2?
My lords, the definition sections, there are 3 kinds of children who are available, my lords, free for adoption. My lords, abandoned child, orphan child, or surrendered child. My lords, this is
It's 82, volume compilation 1, I think.
compilation A, my lords, we are calling it, and lordships will find it.
Printed 87, actually.
Yes, my lords.
Printed
Page 82
87.
it starts, my lords.
Printed 87.
Compilation, which compilation is it? She said?
Compilation A, my lords.
Yeah, no? In a row.
Yeah. All right.
Also, 87 mein?
Printed 87.
You have
It's
87.
index and 87 it starts, my lords.
87.
Yes.
So these 3 definitions, your lordships will note, my lords, abandoned child to 1. Then, my lords, please see a definition of adoption itself. Process through which adopted child is permanently separated from biological parents and becomes lawful child of adoptive parents with all rights, privileges, and responsibilities that are attached to a biological child. Best interest of the child means the basis for any decision taken regarding child to ensure fulfillment of his basic rights, needs, identity, social well-being, physical, emotional, intellectual development. Child means anyone below 18. Please see 15, child-friendly, 16, child legally free for adoption. Please now come down, my lords, to orphan at 42. Section 2, subsection 42, orphan. Then, my lords, 49, prospective adoptive parents, same as 57. Now permit me to, my lords, take your lordship. A surrendered lordship will note is 60. Section 2, subsection 60 is surrendered child. And sponsorship, an example of which I gave, my lords, is defined at 58. My lords, the general principles, my lords, that are in section 3, there are total 16 principles, my lords. My lords, they've been culled out from the United Nations Child Rights Convention. And, my lords, I want to highlight to your lordships the aspect of number 1, presumption of innocence. My lords, the principle of best interest to develop full potential, principle of family responsibility, positive measures, my lords, and I want to read this one, my lords. All resources are mobilized, including those of family and community, for promoting well-being, facilitating development of identity, providing an inclusive and enabling environment to reduce vulnerabilities in children and the need for intervention under this act. This act is not to promote adoption. This act is to make sure that there are less and less interventions under this act.
You are reading from section 3?
Section 3, principle 6, I placed.
Sixth one, okay.
That's positive measures. My lords, your lordships will appreciate. Just reminding your lordships of X versus Union of India, my lords, judgment that my colleagues have relied on. In fact, we were fortunate that your lordships gave us the privilege to assist your lordships in that. Medical termination of pregnancy is the border, in our respectful submission, where the individual rights end. When it comes to, my lords, child that's already born or unborn in the case of ART and surrogacy, it's the welfare of child that alone is the underlying basic principle, my lords. So the parameters will be completely different. My lords, in Navtej, in X, in Nalsa, your lordships were dealing with competing rights. Marriage as an institution, with procreation being such a fundamental core to it. If your lordships read spouse in the Special Marriage Act, my lords, it is going to have impact, my lords, that polycentric spider webs, my lords.
That has been already argued.
It's going to impact the children laws the most in ways that we can't even fathom today. Because children need that certainty of law, that conformity, my lords. And the only reason why any other relationship, though there are other kinds of relationships which are recognized in other laws, go to, my lords, great lengths to protect their children from when they can vote, when they can marry, when they can drink, when they can. And, my lords, the right of repudiation, the right of non-waiver of rights. These are the principles on which they have all been founded. The right to a fresh start, the POXO Act, the entire architecture, consent is immaterial. An independent thought, your lordship said, even a minor spouse would be covered. The entire, my lords, architecture of your lordship's judgments and the statutes has been from the prism of the child and none other. My lords, it's not in my compilation, but there is, my lords, some lines from Justice Bhagwati, my lords, in the judgment of Lakshmikant Pandey versus Union of India. This is 1984 2 SCC 244. Just want to read two lines to your lordships, my lords. This is the judgment where your lordships were dealing with the problems of inter-country adoption and the entire infrastructure, the entire regime of Juvenile Justice Act and CARA came by virtue of your lordships nudge and push in this judgment, my lords. Para 6, just two lines I want to read to your lordships, my lords.
Then aren't you Aren't you serving the petitioner's cause by pointing to this vacuum and what this court did?
My lords, my respectful submission is your lordship may go the slowest when it comes to rights of child.
Yes.
My lords, para 6, just 2 lines, my lords. My lords, I'm sorry, my lords, I'll just read. They're just 2 lines, my lord. Justice Kaul may kindly bear with me, my lords. This is 1984 to SCC 244, para 6, just 2 lines, my lords. It is obvious that in a civilized society, the importance of child welfare cannot be overemphasized because the welfare of entire community, its growth and development depends on the health and well-being of children. Children are a supremely important national asset, and the future well-being of the nation depends on how its children grow and develop. The great poet Milton put it admirably, and he said, "Child shows the man as morning shows the day." And study team of social welfare said much to the same effect when it said physical and mental health of a nation is determined largely by the manner in which it is shaped in the early stages. Just that much.
This is well taken, but you must show children in the context of same sex.
My lords, my respectful submission is from the perspective to show to your lordships that this architecture is carefully crafted, my lords. My lords, here heterosexual couples also don't have rights that equate to them. My lords, there are categories within categories created. Man and woman don't have same rights. A single man and a single woman do not have same rights. So from that perspective, my lords, there is no, in fact, the only recognition is to the child's right. In fact, when I'll show to your lordships, my lords, your lordship saw that section 3, my lords, with me. My lords, then please come to straight away chapter 8 of the Juvenile Justice Act, my lords.
Since we've given you 30 minutes, we are already now 45.
I'm sorry.
So no, not at all. You made a very valid point, and you never, yeah, everything that you say is always very precise and full of substance. So just formulate your submission so that, forget the submissions, we'll read the submissions, of course. But if you can just formulate it, so that then we can take it down and then we can focus on it.
Lordships may go through only my note. Just part B is the portion that I've dealt with. I'm just going to quickly tell your lordship.
If you can just sort of highlight what are the key areas, because I think now we've seen the broad architecture, etc., of the law that you have showed us. You can formulate 3 or 4 key submissions, and then we can.
My lords may note, my lords, in the CARA adoption guidelines, the latest ones are of 23rd of September 22. That's at page 228, my lords, in this compilation A. And
just 1 second. Let's just take it 1 second.
228, my lords.
3rd of September.
My lords, this is 23rd September 22. These are the latest guidelines, but I put the old guidelines of 2017 also, and there are very little changes. The architecture continues in the same manner.
Ms. Mati, what page?
My lords, this is page 228 in compilation A.
Compilation A.
And my lords, your lordships will pay close attention, my lords, is my respectful submission to the general principles governing adoption, regulation 3, regulation 4, child eligible for adoption. My lords, this OM that came was from steering committee, my lords, discussions. One point that was put was that child is trans. How is he dealt with in CARA guidelines? CARA guidelines make no distinction. What is the gender of the child? What is the disability of the child, if any? What age? Well, so protection is given only on 2 occasions. What is the age on which it is given? So lordship will have a quick look at regulation 5. That gives, my lords, regulation 4 gives child who's fit for adoption, and regulation 5 gives eligibility for adoptive parents. That's at page 230, my lords. Your lordships will see that man-woman relationships are immaterial. So a man cannot adopt a young girl child. And it is in this manner, my lords, that it has been crafted. Then 2 years of stable married relationship is extremely critical. My lords, that your lordships will find in regulation 5. My lords, I also want to draw your lordship's attention to, my lords, seniority in regulation 44 and root search in regulation 47. My lord, seniority, your lordships will find.
Sorry, regulation 44 and.
Regulation 44 deals with seniority of prospective adoptive parents.
And
my lords, regulation 47 deals with root search. So every child is entitled to a root search, adopted child also. when either if he becomes a major, he is entitled to do that on his own or through his adoptive parents. And my lords, in the entire architecture, only at one place the biological parents' rights is protected. That is Regulation 47, Subregulation 6, where it says that the right of an adopted child shall not infringe the right of privacy of biological parents. This is the only place. So if biological parents wish their privacy to be protected, then this root search will not be given. My lords, I've given in yesterday's compilation a flow chart of how adoptions happen, my lords. My lords, I've given a data also. In fact, I took from CARA data. You'll also find that at page 1 of my yesterday's compilation. Roughly, my lords, I've given gender-wise. How many boys, how many girls for the last 8-9 years? How many have been given up in adoption? How many parents have registered? So roughly, to give your lordships an idea, there are about 30,000 parents who are registered prospective adoptive parents waiting for adoption. And the children, my lords, here who are in the pool are less than 1,500. There is a mechanism for, my lords, you have to reserve every prospective, and then, my lords, there is a mechanism for intra-country is the last resort.
Only 1,500 children are available for adoption across India?
My lords, yes. And not yet available. They are in the pool. My lords, because there is a time period that's available for children who are surrendered. The biological mothers or parents can reconsider if they want to. So there is a mechanism that is laid down, my lords. And then they are put in the, my lords, I've given a flow chart also of how adoption happens. It is only through Caring's portal. No interference by humans. It is a portal that is automated, my lords, completely. The option goes to the next in seniority as a prospective adoptive parents. They are given 48 hours. They have to give their ethnic background, their choice, gender choice. My lords, the home study form that's a schedule in this, my lords, in these regulations is so exhaustive. You have to disclose not just your health conditions, income, your parents, your other family members, your children. My lords, it is so comprehensive that because it's important. Where the child is, because there is a process of matching that has to happen. After the parent decides that this child might be fit, there is a matching that has to happen, and it's only after that matching that the child is, my lords, given.
Just a question out of curiosity. We appreciate how much effort has gone into ensuring that the child is safeguarded in every which way when he or she goes to a home. What is the timeline ordinarily for an application once a party applies, a parent to be applies, and it matures by actually handing over the child to that adoptive parent?
I've given that in my
Do we have data?
But 3 years.
Do we have data of neglected children who are in care institutions and who are not, of course, not adopted? Do after turning 18 go? I mean, I won't use the word they are turned off, because care institutions don't cater to any adult.
Yes,
At the age of 18, if the child is not adopted or not cared for, in the sense that there is nobody to sponsor her or him, and he becomes an adult.
Yes, ma'am.
What is the future of that young adult who was a child till then? We have, I mean, there is no data. Actually, there is no data. And if you say 30,000 applicants are
Prospective parents.
of prospective parents, then 1,500 only are available.
Yes.
Isn't it a matter for concern that we look into every care institution? And there are thousands. We have, at least in Delhi itself, more than 50.
My lords,
And Tamil Nadu, we have, I think, 250 or so.
My lords, this is the data of, well, if your lordships will see page 2 of my yesterday's compilation of legally free children available as on 28th of April 2023. The CARA guidelines prescribe a procedure in which the child has to be declared free for adoption. My lords, it's a very razor thin edge walk, my lords. The child is being separated from biological parents, surrendered parents, or orphan, my lords. Orphan also, my lords, there is a provision for family adoption, because, my lords, our culture, we are polycentric even in families. There will be nani, dadi, masi, mama, buas, whole lot, my lords, and they have right of, my lords, accelerated rights of adoption for family members. So there is the whole process. If the process is not followed for declaring the child legally free first, before giving up in adoption, it is going to I just want to quickly, my lords, just tell your lordships what the rest of my note is. Lordships will just see that, my lords, I have also, my lords, I've adverted to in between the ART and the surrogacy mechanism is also like that. I just quickly want to mention this, my lords, the National Board of Surrogacy and ART, they were referred some, my lords, issues that why are you not allowing donor gametes in a surrogacy? My lords, the answer very clearly that has come from them is emotional bond of the child is very important. We can't even take 1% chance. So they say between the egg, the sperm, and the uterus, at least 2 of them have to be of biological parents. So while ART allows donors, surrogacy, where you're using the uterus or womb of another woman, altruistic, no commercial, because now the regulation is very clear. You can't use donors. Though Malad's Code 5 will deal with those challenges, but the reasoning that has come is that there has to be a strong emotional bond of the parents who are going for these assisted mechanisms. Malads, we have given, I think I've covered most of it, Malads. I would draw your lordship's attention to, Malads, one more aspect. The special provisions with regard to children, to women, my lords, is also something that your lordships will have to look at very carefully. We have made a compilation of, my lords, laws where women are protected by virtue of their married or domestic relationships.
Thank you, Ms. Bhatti.
And my lords, one more thing, we made a chart of these 34 countries which have in some manner recognized their civil unions, though it's a phenomena only of this millennium, my lords. But they have recognized, we made a chart, my lords, we've given a source of that also. 27 of them have gender neutral rape laws. Social fabric is different, my lords. That chart your lordships will find, my lords, in our compilation C at page 1492. The source is also there, my lords. 27 countries gender neutral, 4 are gendered, 3 we could not confirm because they were in languages, my lords, though we tried AI of the internet to get the sources. My lords, I'm very grateful to your lordships. I had, my lords, just written an opening line. If your lordships will permit, I'll read it, my lords, at my closing. The entire endeavor of ours is to present to your lordships that the architecture of child-centric or child welfare laws is very carefully crafted with welfare of child being paramount. Any general declaration reading in spouse instead of husband and wife will make laws relating to adoption, assisted reproduction, surrogate reproduction completely unworkable. Even for the legislature, my lords, which has the tools of wide consultation, expert and specialist advice, my lords, options of calibrated and gradual solutions, opportunities of amendment, savings and repeal. That, to my mind, is a very, very important tool, my lords. The option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance on one hand the competing rights and on the one hand protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhatti. Thank you.
I am very grateful, my lords. Opportunities of amendment, savings and repeal. That, to my mind, is a very, very important tool, my lords. The option of adoption, savings and repeal. My lords, they will also find it very onerous responsibility to balance on one hand the competing rights and on the one hand protecting the parents' patria responsibility of the welfare of the child, because that is non-negotiable.
All right. Thank you, Ms. Bhatti. Thank you.
I am very grateful, my lords. Your lordships have given me this opportunity.
Yes, Mr. Maninder Singh.
My lord, only a couple of minutes, my lord, because the written submissions are already filed. My lord, if your lordships kindly have, my lord, the written submissions coupled with the small compilation of judgments, my lord, which are in our name. Because I tried to find out the PDF number, I was instructed, my lord, to...
We have the written submissions.
Yes, my lord. Now, I have only 2 points to make, my lord, in support of the same submission.
What are the 2 points?
Yes, my lord, first of all, on the point, my lord, that under Section 4 of the Special Marriages Act, by virtue of, by process of interpretation, my lord, it may not be permissible for recognition of same-sex marriages.
Just 1 second. Yes.
Well, under section 4 of the Special Marriages Act, all sub clauses are conditioned in
That's
addition.
the-
I don't want to repeat.
And what is
it.
the second point, Mr.
Second point is, my lord, on that as late as 2022, my lord, I have placed 3-4 judgments of your lord, my lord, of the different courts, which, my lord, 2 are Privy Council and 1 is from Hong Kong, my lord, where 2 out of the 3 judgments where similar rights had been claimed, my lord, were declined. And in one of the judgment, constitutional validity of declining this right, such a claim, which was placed before the court, my lord, is rejected. That is, that a provision we say, no, there would not be any recognition to same-sex marriages, which was put in question on constitutionality, is declined. My lord, if your lordship will just have a look at the judge, small note, my lord, I'll just
Yes.
show lordship the provision.
It's like that DOMA, the DOMA.
Page
Yes,
18.
my lord.
DOMA was struck down. Here you say DOMA was upheld.
Yes, my lord,
Page
yes, your
18.
lordship is right.
Page 18 of your submission.
Yes, my lord, if your lordship may just give me, only make a note, my lord, in para 14, we have also relied on section 112 of the Indian Evidence Act in support of the first submission. And then, my lord, if your lordships come to para 16, my lord, which is extremely important.
1-6.
Yes, 1-6 at page 7, where 3 provisions of 3 personal laws, my lord, where there is that ability to procreate, which is one of the conditions in section 4, is a ground for divorce. In all the 3, my lord, personal laws of Hindus, Christians, and Muslims, which is, my lord, mentioned in para 16. And then, my lord, if your lordships rightly, my lord, pointing out
Those foreign cases you wanted to show.
yes, my lord, page 19 bottom, the Italian Constitutional Court, my lord, where the Article 29 of that, my lord, Constitution, which, my lord, is reproduced at page 11 of the note because a reference is made earlier. Just make a note of, my lord, Article 29, which, my lord, was very wide, much wider than section 4 of our act.
Article
where-
29, where, Mr.
My
Sorry,
lord, if your lordship may kindly see page 11,
21,
page 11 of the note,
right,
Para 21.
okay, thank you.
page 11 of the note, my lord,
This is that Oliari, the
Yes, my
judgment
lord.
of Republic.
para 21, Article 29, if your lordship may kindly see the second part of it, marriage is based on the moral and legal equality of spouses. So, my lord, by repressing this word spouses when the right was claimed, my lord, that is declined at bottom, my lord, page 19 bottom, going up to the next page. Kindly see para 31. And, my lord, if your lordship permit me, I've kindly come to 20 and 21, extremely relevant, my lord, and your lordship may also keep 2 things in mind. The argument of discrimination and classification, which Mr. Dwivedi had also addressed, I don't want to add. And, my lord, the benefits to flow from such recognition, which, my lord, an argument raised here also, both the arguments raised, both are taken up squarely, my lord, directly, and, my lord, debated, considered, and declined.
You cited Oliari as well as.
And, my lord, yes, my lord, and your lordships have considered Oliari in, my lord, the pages judgment, but if your lordship may kindly
Para 34 is your Privy Council judgment.
yeah, and, my lord, Privy Council, in one of the judgment, my lord, just give me a moment.
Of Cayman
That is
Islands.
Page 21, last 2 paragraphs above 32, both the grounds of discrimination and other benefits which flow from such a legal recognition of marriage have been considered. And if your lordships kindly come to 22, this is para 34 is the, my lord, first judgment of 2022, my lord, in by the Privy Council, where, my lord, section 14(1) of Bill of Rights was, my lord, which is reproduced in para 34, and then, my lord, the consideration thereof is up to page 24 of my note, and, my lord, which was rejected. Kindly come to para 36, which is that section 53, my lord, of Domestic Partnership Act, which created a prohibition against such a recognition. It's extremely important, my lord, for your lordship's kind consideration. The Domestic Partnership Act of 2018, where section 53 created a prohibition, the constitutional validity was challenged, and, my lord, after consideration, at para 76 and 77 of that judgment, which is reproduced at page 24 and 25, it is rejected, my lord. In Hong Kong, my lord, which is para 37, which is also, my lord, 2022, a similar, my lord, discussion has taken place. Similar contentions have been considered. And if your lordships kindly come to page 27, my lord, para 77, kindly read, I'll just read para 77. Your lordship may kindly have regard to the other portion, and I have placed the judgment copy also in the second compilation. Kindly come to para 77. In terms of access to the institution of marriage, it concerns the special status of marriage, which is a distinct concept from the benefit arising from it. The difficulty or even perceived hardship involved in obtaining the benefits of means of legal challenges does not justify a shortcut bypassing BL 37, my lord, which is Basic Law 30.
All right, Mr. Mahendra Singh.
That's
Thank you. Thank you,
Mr.
Mr.
My lord. And judgments are, my lord, enclosed. The full text of the judgment
Yes,
is placed
Mr.
for your lord. I am deeply obliged, my lord.
Thank you, Mr. Mahendra Singh.
Please, your lordships. My lord, I appear for the Akhil Bharat Sant Samiti. I'm not going to repeat anything, my lord. Most of the points are already covered. In fact, I'm adopting, my lord, all the points. I've already filed written submissions. Only 2 points, my lord, I wish to highlight. A, Lord, the concept of marriage in the Indian society is creation of an institution. For example, in the Hindu law, it's a sacrament. Muslim law, it's a contract.
The concept of marriage in Indian society is?
Is, Lord, an institution by itself. Whether in Hindu law, it's a sacrament, so it is a divine angle. In the Mohammedan law, Lord, it's a contract. Various facets. Now, Lord, concept of same-sex marriage, therefore, would be virtually like an attack on the very institution of marriage, which has been traditionally known in this country. And Lord, we have to be very clear about it. There is no doubt that in Nautej recognizes the right to privacy. Lord, right to privacy is recognized, but your lordships have seen that, Lord, observation, where they have said, by this we don't mean the marriage, it's the union.
Right. What is
The second point, Lord, that I want to tell your lordships is, if your lordships have a look at the sections 19, 20, 21A of the Special Marriage Act, Lord, if you marry under this law, Special Marriage Act, then it's not connected to the Hindu Marriage Act, but it also provides that the two Hindus can marry. Now, if two male Hindus or not two female Hindus marry thereafter, what implications is going to have on the other law? That also is required to be seen. Creating, Lord, a mere civil union is fine. That therefore there would be no problem about a civil union or a declaration that they need not be harassed, or because it's, the prohibition part, Lord, is a different aspect. But creating an institution of marriage itself, giving them all other rights, Lord, will interfere with all other.
Yes.
So you are saying that there is no problem with a civil declaration of a civil union per se, but
Civil union, Lord, and that already has been given in the right to privacy. By privacy, you may, Lord, in fact, in my written submissions, I have highlighted and I have said so, that declaration of civil union is a different thing. But insofar as creating them as an institution of marriage will be virtually, and number two, Lord.
With my Lord's permission, given that I have only 20 minutes, and which I expect may not even happen, I'll do my best to simply formulate my position. And as opposed to reading out from anything, kindly allow me to just engage in the bench, because my written submissions capture my position that's already been shared. So there are two aspects.
Just give us 1 second. We'll just go to your written submission. So as we are arguing, we can also keep a track of your submission.
If I may, Milords, an additional written submission.
Additional submissions or the original one?
The original, the additional is a one-page note, and I'll anyway address it. So my Lords could perhaps refer to the first written submission.
So what is broadly the line of...
Milords, if I may say so. The first law of thermodynamics effectively encapsulates the entire position when it comes to physics, and from there, corollaries flow. So the central position that is effectively placed before my lords is with respect to the distinction between fetters and powers, which is to say whether this particular area which the petitioners seek to espouse before my lords is an area which falls within either prohibited areas, or is it something that falls within the area for my lords' adjudication? That is the central issue. And I think that is the forest that is thought to be presented before my lords. I am here to perhaps unpack a few leaves for my lords' consideration. The question of legislative competence is just one aspect of the issue which hinges on separation of powers. But I go a step further, which is to say that when the petitions raise the question of change in heteronormative attitudes, does the society have a right of agency to participate in these proceedings or not, at least in this particular issue or not? Because this is not a question of separation of territories between different organs of the state, but it fundamentally hinges on the right or the agency of the society to participate in this particular discussion. And that is the central problem when these kind of issues and subjects are taken up by the court of law, as opposed to leaving it for legislative prerogative to apply its mind. Point number two, during the course of these proceedings of the last 2 weeks, quite a few times I've heard the submission being made that it's a liberal democracy, it's a liberal document, so on and so forth. Does it mean that social conservatism has absolutely no place within the meaning of the Constitution? Does it mean that the society does not have the right to draw a few red lines to basically say thus far and no further? That is the central question. I represent a women's organization which equally represents the right of children. And therefore, as a civil society organization, the question that is being raised is that the nature of the prayers raised in the petition has the consequence of individualizing a socio-centric institution such as marriage, which is to say, as long as it is a transaction that takes place between two individuals who are consenting and who are not prohibited by any prohibition of degrees, so to speak, the rest of the society has absolutely no say as far as this institution is concerned. This, I'm sorry to say, fundamentally demeans the institution of marriage and takes away its social character. So these are the meta questions that I think which arise for consideration before this honorable court when these kind of petitions are filed. I'm sorry to say this, and let me try and perhaps tone down the rigor of my submission to the extent of saying, I believe that they have a cause. I just don't believe they have a case. The cause is different from the case. And it is important for the court to seriously consider one aspect here. When there are issues of legislative competence, there's another figure, so to speak, which is involved. And that figure's powers come under Article 111 of the Constitution, which is to say that if a legislative proposal ultimately meets with the consent of both the houses, ultimately it has to go to the Honorable President. And the Honorable President also has the power to recommend amendments to a legislation. Therefore, this is not just a question of legislative prerogative or legislative sovereignty, either from an external or an internal perspective, but there are multiple dramatis personae and stakeholders of this particular equation, the society being the chief. Because ultimately, the petitions raise the question of changing the paradigm with respect to heteronormative attitudes of legislations in general. It is not just about the SMA. Plus, my lords is not dealing with the religion-specific legislation here, it is the SMA, which means all the more the society's participation when it comes to the SMA is warranted, is mandated, is compulsory. Because at least if it were to be with respect to certain, let's say, religion-specific legislations, it can be said that there is an identifiable group which has a locus to argue here. But when it comes to the SMA, it can't be the argument that only those who subscribe to the values of SMA are allowed to participate in these proceedings. Secondly, as has been already submitted, Section 21 of the SMA has a direct bearing on personal laws. So even with respect to SMA, the society has a right to participate. The reason why the additional written submissions become relevant is because I filed an annexure, which is the Manual for Parliamentary Procedure of 2019, which was published by the Ministry of Parliamentary Affairs. And that particular manual, so to speak, has Chapter 9, which deals with the business of legislation. Close to 30 clauses exist detailing the manner in which a legislative proposal is to be considered in the first place, how the ball is set rolling. And in that, if I may just refer to my additional written submission here, I'll walk my lords through the relevant portion here. Additional written submission, my lords, has a copy been given to the other side? Please hand it over.
We have it here.
Please, minutes. So para 1 effectively has captured my position with respect to Article 111, but the second paragraph is where I placed reliance on the Manual of Parliamentary Procedures. Does my lords have it?
Yes, we have it.
For the benefit of the bench, may I just read this out?
Which para?
Para 2, page 2.
Para 9.2?
Exactly. So para 2, so I'm reading out from the written submission because that
okay.
captures.
Right.
And the document itself is annexed. So let me just read out the submission, Vilas. May I?
Yes.
Please. Does the rest of the bench have it?
Yes, in addition to the above.
Please, in addition to the above. So can I just read out para 1 for the sake of completion? I'm so sorry. May I? Please.
Yeah.
It is humbly submitted that apart from circumvention of legislative prerogative and sovereignty, violation of the doctrine of separation of powers seriously impinges and encroaches upon presidential prerogative under Article 111 of the Constitution. Under the said article, firstly, the Honorable President has the right to receive the bill for his assent after it is passed by both houses of Parliament. This translates to countervailing obligations on the Parliament to present the bill for the Honorable President's assent. Further, under the article, not only does the Honorable President have the right to withhold assent, but also the power to recommend amendments and also reconsideration of certain specific provisions in a certain bill. Now, paragraph number 2. In addition to the above, reliance is also placed on the Manual of Parliamentary Procedures issued by the Ministry of Parliamentary Affairs in July 2019, which contains a specific chapter, Chapter 9, titled Legislation. My apologies for the speed. I'm just trying to keep up with time here. Please. The said chapter spells out in great detail the steps to be undertaken in promulgating a legislation. Critically, clause 9.2 deals with the pre-drafting stage of a legislative proposal, which is divided into 4 broad stages that include consultation between the concerned ministry to which the legislative proposal relates and the Ministry of Law and Justice. Critically, the latter ministry shall review the legislative proposal for legal and constitutional feasibility, validity, as also, and here I quote, necessity and desirability of such a proposal. Clause 9.5 envisages approval of the cabinet followed by an assessment under clause 9.6 of the expenditure involved. Critically, clause 9.7.1 envisages securing the recommendation of the Honorable President after the introduction of the bill, which is different from the assent sought under Article 111. Then, my lords, clause 9.12 speaks of the possible referral of that particular bill to a select committee or a joint committee or for circulation for public opinion. If I may say so, and I say this with the deepest of respect and the greatest of humility that I can command at this point, that the judicial mechanism cannot be a substitute to any of these steps, especially when it comes to such a serious issue. And I draw from Hindu law here that the purpose of marriage or the object of dampatya is a child, is procreation. Now, therefore, comes the central question with respect to all the permutations and combinations which my lords posed by way of circumstances. What happens to a single child? What happens to a single parent? What happens if it's a homosexual single parent? So on and so forth. Allow me to answer this question in a slightly different fashion. Public morality is decided by normative attitudes. The norm is decided primarily by the mainstream. This is not a majoritarian argument. This is a statement of fact in a democracy. Point number 2. When normative attitudes are sought to be revisited, to say that those who constitute the norm don't get to participate in this discussion because that particular process and that particular, let's say, dance of democracy is sought to be circumvented by using the instrumentality of the court to secure a certain outcome, I'm sorry to say, defeats the purpose of advocacy. Those who are interested in convincing the society are expected to engage with the rest of the society to make good their cause. The judiciary cannot be a substitute to this particular process, because then that effectively replaces societal cogitation with, I'm sorry to use the words, judicial paternalism. That can't happen. 3, the benefit of revisitation of a judgment with respect to such sensitive issues, even if it exists by way of clarifications, I'm sorry to say is not an adequate substitute, it's a suboptimal substitute. Because if the principle that has been established by several judgments is that a judgment is not to be read in the manner of a statute, then there is no precision which can be imparted to the language or findings. And therefore, the principles of statutory interpretation don't apply. So we are left with greater uncertainty. Please, may I? Please. The point that I'm perhaps trying to make, and which is what I'm trying to draw the court's attention to, is that the Nalsar judgment that they placed reliance upon extensively, there is a plus and there is perhaps a downside to it. The plus is the judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction is to read a judgment for what it is not. Secondly, there are only three in places.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millets. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the two opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here, which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history, is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible. That's one. Then, Vilas, the submission with respect to international law, all the general instruments apart, the Yogyakarta principle, specifically clause 24.e, specifically leaves it to countries to decide if they wish to have recognition with respect to marital unions. So it's not as if there is some kind of a binding precedent here, or there's no international instrument that says that you shall. I'm not arguing for it should not be. Kindly let this caveat is important. I'm simply saying, if the door of judicial intervention in this matter is open for one case, even though the cause may be worthy, what does it do for the future? Because ultimately, it's not just a question of one matter. It's a question of the future as well. So therefore, there are specific aspects that relate to the issue in question, and there are general aspects that relate to the separation of powers and societal participation that go well beyond this matter. In light of this, my lords, my only humble submission is that there are other issues to be dealt with, and allow me to just point this out and use this particular forum to advocate only one aspect. Having actually engaged with certain transgender activists and also having worked with them, I know for a fact that one of their biggest problems is trafficking, them being pushed into prostitution, them not having legitimate livelihoods. I am not reducing or dismissing anybody's concerns with respect to what is their priority. Let me clarify that. I'm not making that submission at all. But these are certain Maslow's needs which have to be completed first and which have to be addressed first before we get to the next step. That's all I have to submit. I'm so grateful for the kind. Please, Minister.
Lord, during yesterday's dialogue, my lord, it fell that there is a possibility of a declaration being made, something less than marriage, but something more than the present status. Lord, having examined that, my lord, why, my lord, that may not be a correct course of action, my lord. Lord, your lordship's declaration would be a law within the meaning of Article 141, binding all, not just all courts, binding the whole nation. The difficulty would be this. Lord, any declaration of law would bind every individual in the country who is not before your lordships. In case of a law, every individual is represented by his chosen representative. That is the first issue. Your lordships are aware about the judgment in that baker's case, where, my lord, one baker refused to bake a cake in a same-sex marriage, and, my lord, he was prosecuted, etc. Similar thing happened, my lord, after the judgment of the American Supreme Court, my lord, 5 versus 4, one pastor refused to perform the ceremony of marriage. And he was sought to be prosecuted, and they have to come out with a law, what is called, my lord, the Pastor Protection Act. Now, examine, my lord, a situation where your lordship declares the law. Your lordships would obviously not be declaring the contours of the declaration, the regulatory powers, what will be the regulation, who will be bound, who will not be bound. Suppose someone goes to a priest for performing a particular ritual, and priest says that as per my religion, it is only the husband and wife who can sit, a man and a woman who can sit in performance of that ritual. I will not be a party to it. I am posing a question to myself, would he not be guilty of contempt of your lordship's declaration? Lord, what would be the position, my lord, in case of, say, visa? My lord, where a wife gets the entitlement to visa, but only
See, that's a matter of that priest's fundamental right to follow his conscience and faith.
Lord, where that conscience stops
See,
and where his
that is
duty
where-
ends
that
or
is where-
begins.
So that's where solicitor, what is the kind, form, content, and contours of the declaration is important.
Correct?
We are all presuming
Yes, my lord.
that the declaration will be in the form of a writ that grant this or grant that. This is what we are accustomed to. What I was hinting was, as a constitutional court, we recognize only a state of affairs and draw the limit there and say,
I am grateful, my lord. My worry was this. Whenever, my lord, a declaration is made either by legislature or by the court, legislature has the wherewithal to regulate the fallout. Your lordships would not be able to, first of all, foresee, envisage, comprehend, and thereafter deal with the fallout of that declaration. Fallout can be manifold in various facets of life. In
You're
various,
basically
my lord,
therefore saying that any declaration of this court will really, in that sense, apply to every one individual in the nation and preempt the legislature from considering.
no, my lord, I am slightly on a different point. It may not even preempt the legislature. Legislature can still do something. But that would be, my lord, and for that, my lord, I would, my lord, one paragraph I'm tempted to read from, my lord, this Obergefell judgment, my lord.
That's okay. We'll read
Only one para, my lord, for my
Just
satisfaction.
tell us the para number, that's all.
No,
Just
I would wish, my lord, your lordship,
More
read
than-
it. It won't take more than 2 minutes. It 2463. 2463, volume 4 of the petitioners compilation. For my satisfaction, please have a look. And this angle, my lord, is missed by all of us. And we also, my lord, feel that there would be some disservice, as Chief Justice Roberts points out, my lord, to the petitioners. And therefore, my lord, I wish to read it. My lord, kindly have a look at 2463.
Just read it.
I'll just read, my lord. When decisions are reached through democratic means, some people will inevitably be disappointed with the result. But those whose views do not prevail at least know that they had their say and accordingly are, in the tradition of our political culture, reconciled to the result of a fair and honest debate. In addition, they can gear up to raise the issue later, hoping to persuade enough on the winning side to think again. That is exactly how our system of governance is supposed to be. But today, the court puts a stop to all that. Well, this is what, in my submission, the declaration would mean. But today, the court puts a stop to all that. By deciding this question under the Constitution, the court removes it.
It's very important that you read that. What is put out there is
Yes.
the Chief Justice is highlighting that the declaration that they have a right to marry. What was that? Justice Kennedy declared that gay couples have a right to marry.
Correct, my lords.
Now, we are intensely aware of that. We are intensely aware of that.
I'm grateful, my lord. Kindly, my lord, something further which is on a slightly different point. Therefore, I would like to read it fully, my lord. There will be consequences to shutting down the political process on an issue of such profound public significance. Closing debate tends to close minds. People denied a voice are less likely to accept the ruling of a court on an issue that does not seem to be the sort of thing courts usually decide. As a thoughtful commentator observed about another issue, the political process was moving not swiftly enough for advocates of quick, complete change, but majoritarian institutions were listening to and acting. Kindly avoid, my lord, the citation part. This is crucial, and this is another dimension which Chief Justice Robert gives, my lord. Indeed, however, please note this. Indeed, however, heartened the proponents of same-sex marriage might be on this day, it is worth acknowledging what they have lost. From their point of view, the court says, indeed, however heartened the proponents of same-sex marriage might be on this day, it is worth acknowledging that they have lost and lost forever the opportunity to win the true acceptance that comes from persuading their fellow citizens of the justice of their cause. And they lose this just when the winds of change were freshening at their backs.
Thank you, Mr. Solicitor.
My lord, only last, my lord, it's my duty, my lord, therefore I am pointing out. My lord, at the outset, I said that we have written letters to the state governments. My lord, there are 7 responses. I'm not reading them. From Manipur, Andhra Pradesh, Uttar Pradesh, Maharashtra, Assam, Sikkim, and Rajasthan. I'm placing them on record. Rajasthan takes the position that we have examined it and we are opposed to the position, my lord, which the petitioners are taking. All rest say that this needs a very intense and expensive debate, and we would not be able to respond immediately. My lord, we have received this. I'll, my lord, file it on in the registry with copies to the other side, my lords. So, my lord, these are my closing submissions, but I'm just putting it on record, my lord. I'm not reading them. They are 1.5 page closing submissions, my lord. I'll place it on record.
Yes, Dr. Singhvi.
Amalas, your lordships has heard us very patiently. I've either been present or been made aware, Malas, so lordship may take it. I know, Malas, the broad trends of the argument, and I'll answer them one by one. From mere cohabitation to a mere, I use the word mere, Malas, declaration of same-sex marriage, to a further declaration of same-sex marriage valid under SMA, which is what I'm asking. There's a difference between my 2 and 3, Malas. Same-sex marriage valid under and through SMA. From that, this whole, Malas, excessive to the point of being, Malas, actually wrong emphasis on legislative intent. Put in 5 different ways. Go to the legislature, original intent, rewriting, judicial legislation, judicial surgery. I'll be dealing with all. I'm just saying, I'm cognizant of all that. Then to the, what we call the scare argument. Oh, my lords, how will it work? The workability argument. It's an attempt, to create. I'll be dealing specifically with the workability argument. And then finally, to the notice and objections. Now, I will be very pointed. It may not happen in the sequence my Lord would want it, but I'll be covering all this. But my arguments are broadly under 3 heads. And your Lordship may kindly consider following those 3 heads, because they will come. Sometimes your Lordship's query may relate to the 3rd head. Lordship, rest assured, it will come there. The first head, with great respect, is
that a constitution compliant reading.
We didn't respond to this, my lord. Your lordship said we'll not go into this. Notice and etc., my lord.
No, my lord did not give a judgment, my lord. Your lordship made an observation.
We're not going into it in these.
With respect.
Did say therefore we didn't.
As I recall, when the arguments were being addressed,
I argued it fully in the opening.
we said that this is common to, this is not specific to the same-sex
Heterosexuals also.
And therefore, we said we'll not really deal with it in this batch. We have petitions which are pending.
That's what your lordship segregated.
Narasimha and I have petitions.
May I just say?
That's what we didn't waste your lordship's time.
I argued it fully in the opening.
But Dr. Singhvi,
your
you keep it aside because we haven't heard them. Otherwise, we would have pointed out to them that they have missed out on.
That is, well, according to us.
Purposefully we did
That is, well, if your lordship has to hear them briefly on that tomorrow. Well, that is the heart, the heart of our objections.
No, 1 second, Dr. Singhvi, we have petitions which are pending specifically on this challenge. And the reason why we thought we'll not deal with it in this batch of matters is that that's a matter which is common to both heterosexual couples as well as to.
I was addressing that argument. Your lordships, just 1 minute, Mr. Mehta.
I'm sorry.
Well, your lordships observed when I argued it fully in the opening. Your lordship said that because it is common. I said, well, just 1 second. I said that merely because it is common to another segment.
If you don't mind.
I'm sorry.
Inherently unfair to the learned solicitor and all those who followed on this side, that they went by our telling them that we are not going to.
Can I just clarify? I hear a lot
Together with the subject wise, and we consciously decided that
is saying what you are
And in a sense, you know, our suggestion really led them to a sense of weakness that the
no. I am
with it.
far be it from me to take away any natural justice from anywhere. That's not the point. Give me just 2 minutes. I raised it, argued it fully. In the course of arguments, your lordship observed, at which time only Mr. Ramachandran was there, Mr. Grover was there. They protested that this is the heart of our claim. The lordship said we'll take a call later. Now, if procedure is violated, your lordship certainly may hear them briefly tomorrow. But according to us, the heart, but I'll take only a very short while on that. I've argued it fully in the opening. Your lordship's point was that if heterosexual couples to whom this regime equally applies are not present before us, should we not take it separately? That was a short point made by us. I have dealt with it fully in my written submissions. Your lordship's test is a positive test.
See, Dr. Singhvi, just answer this.
Yes.
We were not here when the reference was made. There is no reference order per se. The order was implicit on this premise that the claim for same-sex marriage was being considered. The court, to be fair to the court, nobody pointed out these nitty-gritties of the claims, the details of these claims, or even Section 7 SMA. Therefore, to stand up and say we have been heard, and please insisting that we must be heard and you must have a ruling is not up to you. No, because see, orders do not reflect. There is a consensus. The consensus was that let the same-sex marriage claim be heard.
Can I just say? Your lordship will recollect, I argued almost for half an hour on this issue.
You did.
Then, after that, ultimately the only issue is the lordship has not heard them. Your lordship may hear them briefly because, your lordship's test is, give me a minute. My lord, the Chief Justice's observation, I just want to take 2 minutes on that. Your lordship's test is that is an identifiable class genuinely aggrieved with locus before me. If a genuinely aggrieved identifiable class like me, which is directly agreed by that is before your lordships, then your lordship will not hear me on the basis that another class also is not before your lordships. The only issue of heterosexual couples we are not concerned with, we are saying that the notice and objections regime, ultimately it boils down to only
time. Look at it this way. One second. There's another problem.
Yes.
Your argument in the challenge to the notice provisions postulates a verdict in your favor that there is a right to marry under the Special Marriage Act.
Of course.
All right. Now, therefore, the question as to whether, otherwise the notice provision doesn't apply to same-sex couples at all, right? Therefore, at the highest, and taking your argument at its highest,
Correct.
your challenge to sections 7 and 10 has to be deferred to a point when we have ruled on the legality of the
I'll tell your
claim to a
lordship-
same-sex
Well, may I
marriage.
say why that might not be correct? Just give me a second. Well, your lordship will the first step have to see whether I am same-sex marriage recognized under SMA. That was my lord observing. That gives me access to marriage under a secular agnostic statute called SMA. It does not give me equality
Also,
with my...
Dr. Singhvi, you have to argue on a demurrer.
Yes.
You have to say that even assuming that
Yes,
you are not
correct,
with me
correct.
on the same-sex marriage issue,
Yes.
even then, my challenge to sections 7 and 10 will survive. Can you say that?
No, but that I'm not arguing, Wallace. I'm arguing on the basis of both. I'm arguing cumulatively. I'm entitled to say...
But we would
that,
have
Wallace,
heard you in your petition on
may I say-
section 7 and 10 if you were right in saying that even if you hold against me on the first point, my second point will survive.
May I put it like
Your
this?
second point
Yes.
is really dependent on the view which
Wallace,
we take
I
on the
bow
first
down.
point.
I bow down.
And therefore, at the highest, what we can do is this.
The two are
that
inextricably intertwined.
At the highest, what we could do is this. Assuming, because we are now testing the hypothesis.
Yes.
Assuming that we give a declaration as that you want, that you are entitled to a right to marry under the Special Marriage Act, that there is a right to marry, so on and so forth. We can say that this particular issue will be dealt with separately in a petition which you will file or in the pending petitions where you may have intervened or...
Petitions are there on this specifically. Mine, Mr. Raju Ramachandran's, others, all directly, already pending here. And they were mentioned, they were added
Because
to this
notice applies to those who are entitled to marry undoubtedly, because that's why a heterosexual couple, there's a square challenge. But we can't hear your challenge unless we rule on your basic point.
Well, I leave it to your lordships with 2 points.
Singhvi, we might be putting the cart before the horse.
Well,
That sense of the...
May I just say this?
That's
I'll
why
leave it
we-
at that. Let me state my point and I'll leave it. My point is, number one, your lordships would decide certainly the declaratory part under SMA. Number two, my point is, when I bow down, my second point of notice and objection arises only if your lordship holds me eligible under SMA, no doubt. However, I say that if your lordship so holds in the first part, the other is inextricably intertwined. It follows, it's consequential. Without that, much of my right is hollow. And thirdly, Malas, the ultimate objection to this is what? I mean, we are in the Supreme Court. Your lordship will hear another combination. But the only objection is that he has not argued. Your lordship will give him a fixed time, half a day, and we'll finish it off tomorrow. Malas. I have already argued. We will take less than 50. At the end of the day, your lordship is rightly concerned about natural justice. And I'm not suggesting your lordship violates that, Malas. That's, Malas, the only way to put it, Malas. Otherwise, I leave it to my lord, Malas. It's a very, I will show, Malas, at the end 10 minutes, why, Malas, assuming your lordships were to give me a declaration that I am a same-sex valid marriage under SMA, the vulnerability, the practical operation, the invitation to violence will make that right 50 to 70% illusory. That's the reason, your lordship completes the... Obviously, if your lordship doesn't hold with the first part, there's no point. Your lordship doesn't have to bother. What will, at the end of the day, what is the objection? He didn't get a chance to argue. According to our understanding, I was not here. My learned friend tell me, lordship said, we'll see later. The lordship did not exclude the point.
For a particular reason which will
did not exclude the point. Therefore, Mullah, I suggest, at least let me finish my argument on that, whatever little argument I have. Your lordship, Mullah, accommodate him in, it's a very short point. He can, Mullah, show those sections that their lordship may have a little bit of spillover.
You respect, Dr. Singhvi. With due
Dr. Singhvi.
respect. Yes, sorry.
Yes.
Yes, this call,
Yes,
please.
the call.
Yes. Dr. Singhvi, see, what is being suggested to you is, let the bench rule on the principal aspect. Are you entitled to the declaration of a marriage or not? You are talking about the right post that being illusionary in some manner because of consequences which may flow. It's not that you are being shut out of that right to argue that.
I appreciate it.
The thing is that it is being felt that since it's an interlinked issue both for the same-sex marriage as well as a heterosexual marriage, it may be more appropriate to hear that out in a particular manner, looking to both sexes of the people. I don't think that should trouble you so much.
I cannot say more than that. I will leave it at that.
There are only two things which can happen. One is you get a declaration, in which case you are heard on the second aspect. Second is you don't get a declaration, then really you can't argue that. So it's not really shutting you out.
I appreciate what my lord is saying. I bow down to it. I will not say more. I made my 3 points. Whether your lordship then Malus still would want to hear it in a subsequent hearing, that's your lordship's Malus prerogative. But Malus, I would still say the lordship will consider seriously my 3 submissions. That's to why your lordship should hear it in this bench. But I don't want to Malus, I want to move
Now, on the main matter, you said you had 3 points, basically, 3 heads.
Third was this, Malus. Third was this.
Right. What is the
So the first is, Malus, there are constitution compliant reading of the Special Marriage Act is within, don't give it down, is within the bounds of legitimate statutory interpretation. That's the first head. These are the heads, fellows. It is neither judicial surgery nor judicial legislation. There are 7, 8 major points under this. I will itemize them and go one by one under them. My second major head, Malus, is to Malus, assure your lordships and assuage all the needless apprehensions created, to show to your lordships, Malus, that the relief I seek, in one sentence, Malus, I am a valid, recognizable same-sex marriage under SMA. That's the proposition. I am, my second head of submission is that the relief I seek is workable. So the workability head. And neither requires this honorable court to create any new social institution. Many of these are phrases picked up from the respondents.
social institution?
Nor to have a new definition of marriage. Nor to have a new definition of marriage. These are all again phrases by the respondents. Your lordship will be creating a new definition of marriage. Your lordship will be creating a new social institution. Nor, thirdly, nor entering into any thicket of personal law or other related laws. My third set of head, Joshua, note it. Joshua decide whether to hear me now or later, or just note the head, brothers. I mean, this is the
sure.
That, brothers, the prayer for striking down the notice and objection regime of the SMA the prayer for striking down the notice and objection regime of the SMA. You keep it here and there. Is an essential and indivisible component. Essential and indivisible component of my prayer for marriage equality. My whole case is about marriage equality. This is an essential and indivisible component of that prayer for marriage equality. Your lordships, without this third head, would have granted a recognition of same-sex marriage, but not equality. It would be a recognition of same-sex without equality. We are seeking two things. One is marriage equality. Your lordship would in some sense grant marriage, but not equality without this third. That's why it's important. And as my learned friend rightly says, without recognizing the extreme vulnerability of the class which faces this notice and objection regime, much of the relief might be made illusory. It's a very, very clear, strong, special vulnerability. I will stick to these three heads, Willis. I'll start with the first. Now, Willis, all these are points under the first. So, Willis, just 2 sentences on what is the heart of my claim and prayer, and then we come to the first head straight away. Well, as I've said, we not only seek, or we do not merely seek, a declaration of the right to marry, which is one way of putting it. Of course, the solicitor opposes even that. One particular class of respondents said, yes, you may give that, but not go further. We do not seek, Willis, merely a declaration of the right to marry, but a right to marry under the SMA by an interpretation of the SMA which would allow for solemnization and or registration of non-heterosexual marriages. That's the heart and the complete case. Therefore, Malus, what we seek is a right to access on equal terms. We are seeking a right to access this social institution called marriage, and on equal terms. The irony is, my learned friends accept that it's a very sanctified social institution. People must have access, but they say not you and not on equal terms.
Through law.
So, Malus, in a nutshell, this case is about interpretation to apply an existing law in a non-discriminatory fashion. There is no judicial legislation, no judicial surgery. Your lordships, fellows, have done much, much, much more. Interpretation of an existing law, no new lawmaking, but in a non-discriminatory fashion, which has two components. A, I should have a right to access on non-discriminatory terms. B, on equal terms. Now I come to my first head, straight away. First head. Melis, the heart of this matter is what? Your Lordship is, well, I'll deal with this bogey of excessive reliance on the legislature. I'll be dealing with this constant argument. Well, is the Constitution, just to digress for 30 seconds, the Constitution is supreme. Because your Lordships, fellows, interpret entrenched rights in a counter-majoritarian manner against the majorities. Every day, your Lordship, the whole Constitution about interpreting and applying entrenched rights against the majorities, against elected legislatures, against electoral majorities, which your Lordships from the framers' time thought could become tyrannical and dictatorial. Otherwise, there'd be no constitution. This constant hearkening that you are the judges, unelected judges who enforce entrenched constitutional rights against elected legislatures, because our constitutional forefathers said that many rights were entrenching precisely because they have to be a counter-majoritarian against the elected legislature. What is so great about a legislature, Melis? Now, Melis, kindly go one by one, Melis. Therefore, Melis, consequently...
Except very small, very small detail,
Yes.
that the legislature is the one which has created this SMA.
Yes.
If you rewind and there were no SMA,
Yes.
where would that right flow?
Well, it's very simple. Let us be very candid, Melis. We cannot keep fictions anymore. The legislature made the Constitution, but it made the Constitution supreme and a special majority to amend it. In other countries, that is enough to say the Constitution is supreme, not the legislature, not the judiciary, not the executive. Here, your Lordship put a supra-added basic structure on it. And who says what is basic structure? Your Lordship say that.
All that is fine. We rewind to the position that existed before 1954.
Yes.
Where could an interfaith couple come and assert that right? That is where exactly you stand today.
Now, Melis, it's a very good, interesting year your Lordship is giving. I have in my written submission even put a photograph. Melis. That's a very interesting year my Lord Justice Bhat is giving. Melis, Brown versus Board happened around that time. There were people who wrote that these are the documents of the framers of the 14th Amendment who said you can never have equal but segregated. The original intent was against. They said we will now interpret it in accordance with evolving times. And the photo I put in my submissions, Willis, is an iconic photograph of 1960 with 4 white marshals escorting a black guard. Purely counter-majoritarian. The 14th Amendment, Travaux Preparatoires, suggested that the original intent was not to allow this desegregation. And the judgment records it. It's a judgment not in the compilations. And a 9-0 judgment in 54, Justice Bhat says, at that time, we are now, what, 75 years down the line. Because it is, evolving. Whereas I have got 2 other interesting examples when I do some research for this case. I'm digressing, but a very interesting example. You should be shocked to know. There were laws passed by legislatures of USA, the country which is the most advanced country in the world. One law said that male people below an IQ of X must be sterilized.
Eugenics.
Because you should not have a society of idiots. I'm being blunt, that's virtually what the judgment says. That judgment was upheld. I'm sorry, no, the law was upheld. Holmes. Second example is very, very interesting and very relevant for today. Well, the biggest change from my time when I joined the profession is, among other things, that from being a refuge of last resort, law is an option of first choice. You would you'd fail 5 exams and then come to law. Now, it's an option of first choice. Secondly, people with no background in law are coming to law. With no correction, fathers, grandfathers are coming to law. Third greatest advance is women. The number of women, when some of us started our profession and now, is radically different. Whereas the second law passed in USA was, the women should be barred from joining the legal profession because of the roughness of the profession. Women are not suited. Also upheld.
We were the first
Well,
to
we
do
were-
away
yeah,
with that.
we have-
I beg what?
We were the first to do away
No,
with
Malas, that is
Sarkari
much more advanced.
records,
Now, Malas, these are, therefore, this whole concept, original intent, legislature, it is unelected judges who are the masters of interpretation of the Supreme Court, of the Constitution. The whole idea is to entrust that power to a class of people who are not buffeted by the majoritarian trends or the majoritarian ethos of a time, which can at times be tyrannical and dictatorial. Well, part 3 is nothing but a counter-majoritarian part 3. What is part 3, Manas? It's an entrenchment against the majority. Articles 25, 26, 27, 29, 30, nothing but counter-majoritarian, Manas. So it's no point repeating. Yes, if your lordship finds that the Ghedan, which is completely test, I am asking 10 units ahead of Ghedan, then it might be judicial legislature or should not do it. But don't not do it because the legislature may do it. That's not a valid reason. If your lordships find that your lordship has to do much more than even Ghedan allows, then your lordships may not do it. If your lordship finds that this is not a correct thing to do, your lordship may not do it. But please don't, Malas, be swayed by this constant majoritarian argument. Elected legislature, unelected judges, majorities. But the whole advance of law is replete with, Malas, examples to the contrary. There'd be no advance in the law, Malas. And we are now talking of Brown versus Board of 1954-55, Malas.
But
Now,
maybe you just said that if you feel that it's not a correct thing to do, then don't do it. Or in other words, if you feel that it is a correct thing to do it, then by all means do it.
No,
The problem is that
even there within limits.
the problem is that the court decide these issues of correctness or otherwise when they are essentially issues of legislative policy and in the legislative
Well,
domain.
your lordships knows it better than us. Your lordships has done much more
That's
in the course of
exactly the point.
interpretation.
Does the judge decide that this is correct and therefore we will do it?
Yeah.
Or is this something which properly
Well,
so called is for the
that's your-
legislature to decide as
well,
to whether it is correct?
I would even go so far as to say that there is a value judgment involved in all these cases. Was Navtej not a value judgment, Malas? Why is Navtej not a value judgment, Malas?
No, not at
Dr.
all.
Singhvi, Navtej the court was within its constitutional bounds.
Because there was a challenge
Because you
to
had
validity
direct
of
challenge.
Is it
370.
a challenge, Malas, by reading down that Article 14 and 15 excludes me on ascriptive characteristics. That's the one sentence summary of this case. Your lordship is preventing discrimination which is practiced by the application of discrimination against me on ascriptive characteristics.
But therefore-
Directly 14,
Therefore,
15.
let's understand your submission.
Yes.
Your argument is that any notion of marriage
Yes.
as a social institution which excludes same-sex couples would be violative of constitutional precept. All right?
In particular, 14, 15, etc.
That's right.
In particular.
Their argument is that marriage is conventionally understood
Correct.
is a heterosexual union between man and woman.
Correct.
You are saying now, in order to make it constitutionally compliant, read that social institution as also comprehending within its fold
Lordship, please.
the union between a same-sex couple.
Because, no, not only that, one sentence more.
That's very different from what we did in Navtej.
No, well, I'm saying, on one ground. One of the grounds of an ascriptive characteristic, one of the grounds of...
started the debate by saying that the Special Marriage Act provisions are void. You have not. You have said that it is raised in
if
this
I can
manner.
kindly
If you read it literally,
I-
it leads to this.
Kindly see what my Lord
Then
Justice has
thereafter
formulated.
you brought in all
No,
this.
Maharaj,
content,
kindly just see what my,
updating, etc.
let me answer, give me a minute, it's very important. Kindly see what my Lord Justice has just formulated. Therefore, I could enter the gate with a voidness challenge on SMA.
Yes, you could.
Yes, Malas. Can I not ask for lesser? Your Lordship,
That's
read
not
down,
the point.
your
It's not a
Lordship.
question of lesser.
Malas, kindly.
Question is, you should be able to say, this is a wrong classification. I'm taking it head on, strike it down.
No, Malas, with
And
respect,
then we
with
say-
respect,
we read
with
it
respect.
down.
The striking down would be on the same articles.
See, this is a very artful way of putting it, if I may say so.
Malas,
This is very artful.
Malas,
You
your
are
Lordship
not
have been on
taking
this
it
side
head
and
on.
one side, so
You're saying that there is a classification which is illegitimate.
Yes.
But you are not willing to take it that far because you have no locus.
Can I, Malas, just...
You have no
I
locus.
don't, Malas, with great respect, no locus may not be right. Give me...
You are establishing, wanting
Let
to
me-
establish a right by opposing a negative, that this is void.
So let me meet both those points. It's a very important part of the debate. Number one, I am entitled to challenge it on the ground of discrimination and an arbitrary exclusion. But the consequence, my lord is saying, must be strike down. Well, if your lordship, within the bounds of judicial review, if, forget this case, are able to read down something, does your lordship not 100 times uphold the act by reading down? Forget this case, what your lordship do? Is the technique wrong? The technique is not...
Proposition 1, if I may say so, is the classification there is valid. Now, you want to push it forward and say it is a valid classification, but...
No, I'm not saying it's valid classification. I'm not saying valid classification. I'm sorry.
In that case, heterosexual classification is not valid according to you.
No, your classification which is invalid becomes valid by your lordship's reading spouse, person, everywhere. It can become valid, but the lordship does it in every law.
But Dr. Singhvi, there was no argument of it being ever invalid. The argument was we need the same benefits as are flowing to those who are in a
Otherwise,
marriage.
otherwise it will be bad.
Statute.
Otherwise, the law would be bad.
But you never laid a challenge to the very statute.
No, Malas, I'm saying I am entitled not to raise.
As we understand.
No, Malas, let me. But I'm asking, forget this case for a minute. As a proposition of law, my lords should not think that there is any sleight of hand. Just for a minute, forget this case. As a proposition of law, am I entitled to come to your lordship's court and say, A, I have direct locus. I'm directly agreed because I'm that class which is excluded. So there's no question of lack of locus. I am that class excluded. Second question, I am the class excluded because the exclusion occurs on ascriptive characteristic of gender or sex or identity. Third, if your lordships finds that there is an exclusion, then while normally the law would be struck down, I am giving you clear, simplest, minimalist answers as to why a reading of person and same sex or spouse will validate the law. I don't want to change any other part of the law.
Dr. Singhvi,
why am I compelled, to challenge its validity?
Even if you were to challenge the constitutional validity of the Special Marriage Act, even if you were to challenge the constitutional validity of the Special Marriage Act, that would be postulated on the hypothesis that any statutory recognition of marriage as being confined to a heterosexual man and woman is unconstitutional. In other words, what you would then seek is an expansion by the court of the very notion of marriage so as to include a class of relationships other than a heterosexual relationship.
Absolutely.
Right?
Absolutely.
That exactly is the problem, because then what happens is that the court, in the course of reading down, which you are then suggesting that it should be done, would be reading down the statute in a manner which would expand the dimensions of the social institution, which is what you seek.
No, call it reading up. I have no problem with that semantics. Call it reading up.
Reading up
is
what you are then going to say is that, look, the Special Marriage Act has taken account of marriage being a notion involving a man and a woman.
Yes.
This is unconstitutional.
Yes.
In other words, actually, if you stretch it further, that any notion of marriage itself being a union between a heterosexual man and a woman is itself unconstitutional.
Now, can I just answer that?
Now, can we go down that far and say that, look, the very social institution of marriage, as including a relationship only between a man and woman, is unconstitutional? Even you won't take it that far.
No, we are saying in the event that your...
That's a social custom.
No, we are saying that...
It's amenable to Article 13.
I'm sorry.
You haven't also taken it that far, and you won't take it that far.
We are saying...
So what is your next line of argument? That by recognizing marriage only in terms of a relationship between a man and woman, the legislature has infringed 14 or 20.
All that we are saying is that if you continue to read SMA to exclude same-sex couples, then the SMA as a legal proposition is unconstitutional under 14, 19, 15 and 21. Just allow me, I've heard it also loud and clear. First point, marriage as a legal institution needs my access on equal terms as heterosexual couples. My stoppage of access and also not on equal terms is my violation of 14 and 15. It doesn't stop here. Your Lordship, next question is, everything different is not unconstitutional. Let us see what is the difference based on. That's question number 2 in an Article 14 analysis. My answer to question number 2 would be that this differentiation, which leads to the exclusion of same-sex couples, is based solely on ascriptive characteristics. Solely. Question number 3. If it is so, then normally its exclusion must be struck down. Kindly bear with me, I'm answering your question. The exclusion must be struck down. Now that may lead to situations of inclusion.
So this part we've understood your submission. What's the next?
That analysis doesn't stop at 3. So first is there a differentiation, exclusion? If there is there a valid basis for it? These 2 I've made. Third still remains. Overall, is it something which your lordship should not do after the first 2? Reading up or reading down. Because of a original intent prohibition. Answer clearly has to be no. Your lordship will never follow the original intent in that sense in this country. Fourth.
Dr. Singhvi, during the hearing on behalf of the petitioners, I think we had trodden all this ground and even moved on. And if I recollect rightly, you said that you would not urge any interpretation which does violence to the other provisions of the statute.
That's the workability.
That's where you ended it and the others took over. So now please focus on what is your core argument.
Workability part, I'm just coming, Malus. That's the workability part. I will be showing your lordships chapter and verse, the workability, because that is told to your lordships. Today, Malus, I'm only on this, on the first part, a mere declaration of marriage or a declaration of a valid recognized marriage under SMA. That's the debate in the first head. I've not come to the second head yet, Malus. In the first head, it is our case that your lordships must recognize same-sex marriage on these legal basis under the SMA. And for that, your lordship has ultimately in the 4th test or the 3rd test only to see that does an original intent bind you? There is no such doctrine in India. Is there overall a policy of the law? The language is, it is permissible for a court to depart from the specific intent of the legislators as long as the proposed interpretation is consistent with the underlying thrust of the statute and within the institutional competence of the judiciary. If your lordship is violating this test, by all means, I'm out of the first test. Well, this is a quote from Ghedan I've just read, just part. Well, Ghedan was much misrepresented, factually different, contextually different. I started when if your lordship recalls my arguments, of course it is. I cited it for the interpretive doctrine of judges not being bound by sterile doctrines of the original intent or the specific intention of the legislators. That is the only reason I cited.
We don't need to go to Gaidan. We have our own homegrown
exactly.
Ratanaria
and your lordships have in fact travelled much more. That was an English case without the constitutional dynamics of this country. So, Malus, your lordships reading up and reading down in a much bigger way is commonplace. Your lordships, Malus, in particular, apropos what my lord just said in S.G. Chaudhary, which is, Malus, in footnote 1 and one more judgment, Lakshmi video. They're all in my original compilation. Your lordship knows S.J. Chaudhary is in my compilation, volume 2 at page 7094, and Lakshmi video is in my compilation 4, volume 2 at page 4510, held this simple proposition, Malus, which is sufficient. Application of a statute ought not to be forever circumscribed by the range of concrete circumstances that its framers intended it to apply to. This is your Lordship, 60s doctrine. Ghedan was one, I've given your Lordship enough Indian law before that. Therefore, I submit.
There's an old one on 14. I think it's Jialal. Jialal is, I think, the one where those living on the other side of the Yamuna were not allowed to hold an arms license. And that rule was, created during the aftermath of the mutiny. I think it's 61 or 62.
Oh, yes.
So the court said that, what is this classification? See, that which was valid, because the insurgents were holding arms, they were concentrating in Meerut and that side.
Correct.
So they wanted to stop that.
So that was a contextual thing of that time.
Correct. So then,
that's right. Then, I go on this to say that your Lordship will then juxtapose it with the agnostic thrust of the SMA. Why was the SMA created? Today, after 70 years of the Republic, 75 years, we have a recognition that the numbers of same-sex or queer people is very large. They were always there, but they were not understood and recognized as a community, that they existed. There was fear on both sides, both on the heterosexual side and on the homosexual side. There was inhibition. Today, what is this case about, that your Lordship provided a secular agnostic platform for heterosexuals. Forget, this category. SMA's entire birth from two things, the long title and the SOR. I'm not showing it again, Lordship. And the text, especially 4, section 4. The whole purpose. Therefore, if the SMA was designed to facilitate marriages, actually, SMA was in that sense not as much, I would say, but a very significant advance. Not so much as recognizing same-sex today, but a very significant advance because it was also dealing with marriages outside the pale of social acceptability. Social acceptability is the heart of SMA. Your Lordships wanted to create a platform for social acceptability which is not there for heterosexual couples.
Now, just a little look at the clock, Dr. Singhvi. We don't want to keep it part-heard beyond the vacation.
No, tomorrow. So I will not.
We have about 50 minutes. We'll rise at about 4:15. So between all of you, please ration the time now.
No, tomorrow, give me some time. You should we do one thing? Rise at 4 o'clock. Give me about half an hour, 45 minutes. Tomorrow we'll finish this side.
Then I want.
Workability. This is a matter of last rejoinder is the last stage. We want that time.
Singhvi, tomorrow is a clouded morning. We have a
reference.
Then we have 2 constitution bench judgments which we are pronouncing tomorrow. Plus, today we had only 240 mentionings in the morning.
Your Lordship may slash
276, sorry, 270.
Your Lordship may shift the mentionings to next week, in a lighter vein, because this can finish too.
And then we have all India.
This is our last slot, in a rejoinder.
You can just
it's the last slot.
One after another. Tell us, because we have heard it for such a long time.
No,
this will be faster to grasp it. You just formulate it and then tell
us.
No,
I'm formulating as I go along. I'm giving your Lordship every discrete point. I'm not repeating a point. But this is a matter of some moment. Your Lordship will give me some time tomorrow. I'll be very pointed. And your Lordship has time from 12 o'clock for this matter, or from whenever your Lordship finishes the other thing.
Only 10 minutes to give a suggestion.
I'll tell you what the practicality is.
Yes.
The reference will go on for about.
This is
What we could do is this, because tomorrow's schedule really, I mean, I must share it with you. We have the reference which we anticipate would be 10:30 to 11. Maybe perhaps a little longer.
Mentioning half an hour.
Then we have two constitution benches, give 20 minutes for that. Mentioning half an hour. So we would be able to assemble at about 12 o'clock. 12 o'clock. So 12 to 1, then everybody will have to wrap up between 12 and 1.
We'll finish it by 1 hour.
But Lord, I just want 5 minutes now. Lord. I have difficulty.
Another 5 minutes after Mr. Rodgi.
Only
two of us will finish.
I want to give a suggestion.
We'll finish.
I want to give a suggestion. Lord,
Singhvi, if you could please do this. If you could wrap up by say about 3:50, then we can give 5 minutes each to Mr. Rodgi and Mr. Ramachandran, and then see who else remains there.
Let me.
1 hour.
In 1 hour.
Yes. 3:30. Well, let me proceed as fast as I can. If I need 5-10 minutes.
Give me 20 minutes because. Please keep going.
Please.
Lord, my friend.
My
Take time tomorrow. Give me and Ramachandran 10 minutes now, and he can continue tomorrow.
Anyway,
Just give.
Now we're in the thick and the flow of Mr. Dr. Singhvi.
Now, let me utilize this time at least. I mean, let me just go.
All right, Dr. Singhvi.
Now I'll go back. So, therefore, your lordships provided a platform of beyond social acceptability for heterosexual couples. All that your lordship has to see whether reading in or reading up within that social acceptability platform is beyond the pale of judicial review. That's the only test.
That's the point.
I'm not asking your lordships. I heavily disagree about judicial
What
surgery.
you're saying is Gaidan methodology and
not Gaidan, but principle.
Okay, whatever it may be, is equally permissible under the Constitution.
Now, kindly turn to para 9 of my note, my written submission. I made a self-contained, the rejoinder submission.
Right? In rejoinder.
Yes, what is it called?
Hai na?
It's got my name on the top of the rejoinder submissions by so and so.
अभी आया है दोपहर को.
Right now.
Where is that?
Yeah.
The mail is it?
सुनो, अब तो इसमें आपने.
We have got hard copy.
किया है. Rejoinder. There is a mail, is it? Mail में
Volume up to volume 18. Huh?
चेतन पेन ड्राइव में कहाँ पर है?
Up to volume 18.
Now, have you got page 9 at page?
Give us a moment, Dr. Singh. We're still looking.
Para 9 at page 5.
Rejoinder is a whole new world now.
Karunanand has given 2.
Is it by way of the conclusion on this point, Dr. Singhvi? Does it begin like that?
By way of
It's done.
Yes, correct. Justice Kaul has got it. Para 9. That's correct. Justice Kaul has got it.
हाँ किसमें डाला है?
Para 9 is at page 5.
Rejoinder folder अलग नहीं है मेरे पास.
It's a 37-page document.
There's an extra. There's actually 15 pages. It's only 15 pages. Or
Yes, you're
more
right.
than 15. How many pages? 19 pages. I'm sorry. 19. Rest is appendix.
Yes, you're right.
Now let's just come to 9.
Is the rejoinder folder as part of written submissions?
Still looking.
Chetan?
Oh,
Because
I'm
it came at lunch, therefore there was a problem.
Let it be located first.
It's sending it to you.
Justice Kaul and Justice Bhat have got it.
No, we have it.
Justice Narasimha also has it.
No, he's getting 8 drops.
You also.
You airdrop it to me?
Airdropping is, your thing is not on.
Mine?
No, this. CJS.
It's on, yes.
Got it? Somebody can just go that side and find it.
Because they took my pen drive to load it in the afternoon.
Can you which one?
Okay.
These written submissions in rejoinder.
Yes, just police computer.
Yes.
Just to
Yeah, sure. Just one second.
give us a moment.
It's a 20-page
Download.
document. Yeah. It's 37 pages, by the way.
37.
Actually, 20 pages
20
is the
is submission.
Yes, to argue and rejoinder. That's
Correct,
his
that's
base.
right.
Para 9 at page 5, internal page 5. In the middle. Sorry. It was never in dispute that when the 14th Amendment was enacted in 1868, its framers did not intend it to apply to desegregation. Indeed, it is popularly recounted that many legislators who supported the amendment supported segregation and the separate but equal doctrine. In Brown, however, the US Supreme Court discounted the specific application intent of the framers and asked itself instead what the principle of equality required of it by way of constitutional interpretation. Similarly, petitioners' interpretation of the SMA focuses upon the underlying thrust and the principle of recognizing and legitimizing marriages unsupported in social conventions, upon which the SMA is founded, rather than asking how the framers intended to decide. That question is wrong, I say with respect. Now, I'm putting that photograph, I've said anti-majoritarian impulses. Unpopular, I'll skip para 9a, but that's an iconic photograph of the 1960s. Come to para 10. Petitioners respectfully submit that the remedy does not involve any judicial surgery, nor the creation of a social new institution, nor a claim for legislation. These are words used by the respondents. Now, kindly see what it involves. Rather, the issue before this court is one of discrimination of non-heterosexual persons from an already legally defined institution on the basis of the prohibited markers under Article 15. Malas, one thing more, Malas. Your Lordship is told social institution. Today it's more a legal institution because your Lordship under the SMA is excluding personal laws. It's a misnomer to again and again bring this scarecrow argument of personal laws. It's a legal institution under SMA, not a social institution. I'm not saying marriage is not a social institution.
It's not as it is
Not,
it is
I can say it, not absolute.
It is enabling the marriage, but it is also assimilating
I
person.
bow down. I don't want to say use the word absolute. My Lord is absolutely right. That matters, I'm not going that far. I'm just saying, Malas, a large amount of that social institution part has been, Malas, circumscribed by a legal construct, which is what SMA is. Prior to that, your Lordships could not venture there without personal laws. That's the point I'm making. Now, just see the middle of para 10 is very important. I've taken the liberty of highlighting it. A right to marry, along with a scheme for its implementation, already exists. Petitioners are only asking for a non-discriminatory access to their existing right and institution. Indeed, petitioners' request is modest. It is to interpret certain provision of SMA in a manner that is both constitution compliant and consistent with the SMA's own underlying thrust. Contrary to the respondent's submission, this does not involve the court in altering the meaning of words or the meaning of marriage. It only brings into the ambit of the SMA a class that was unconstitutionally hitherto excluded. Well, your lordship is just pause here. I'm not on the notice and objection. Your lordship is now being told an equation between right to marry, a declaration to marry, versus a declaration to marry under SMA. Well, Cicero's words are important. Well, Cicero said, well, that a room without books is like a body without a soul. Well, your lordship is being asked by the other side that you recognize an abstract right to marriage without anything under the SMA is really being asking for a body without a soul. That's my submission. That I've said in para 10 capital A. And we have a quote in the top of my submission, which I need not. Mary Robinson, President, Ireland, and also the promises of human rights are like empty shells if they are not backed by concrete actions and meaningful change. May I say, your lordships is what is your lordship being asked? Give a declaration of marriage, but nothing to do with the SMA. These two words, empty shells, apply, body without a soul, apply clearly. Now, 10B, I've said legislative majorities did not decriminalize. Forget 10C, come to 10D. 10D for a minute, It is respectfully submitted that legislative will is not necessarily a neutral, objective, or meritorious manifestation of desired constitutional objectives and constitutional morality. The Constitution is supreme precisely because in many areas it digresses from the wishes of mere electoral majorities. The zealous guarding and upholding of several minority rights, including its many nuances, is crucial precisely because electoral majorities are presumed to be wrong, tyrannical, or oppressive at certain times. So, this is an excessive misplaced reliance on elected majorities and unelected judges on the other side of the equation. Now, let's go to workability, which is the heart of the matter, because I must assuage all these huge apprehensions, which I'm going to show are largely red herrings, created to create some kind of a sphere issue that, oh, what is the lordship being asked to do? How far a lordship will go? Now, let's please see. The main part of this workability or lack of workability is personal laws. That your lordship is being dragged into personal laws. Just bear with me, this is a little important, and I'll go a little slow. Just come to the third line of 11. In particular, section 19 of the SMA severs ties of persons of Hindu, Buddhist, Sikh, or Jain religions married under SMA from their undivided family. At the same time, 21 provides that succession to the property of any person married under SMA is under ISA. Now, the main argument on which, on the very tenuous, thin argument it is argued by respondents is the last 5 lines. Respondents argue that 21A of the SMA carves out an exception for marriages among persons of these 4 faiths, stating that they remain members of their undivided families, last 4 words, thus linking them back to religious and personal laws. Now I'm trying to answer this first point. Well, I've given 2 important tables in para 12. Just see the first table. Prior to 20, because the entire argument is 21A brings back a very minimalist, but a small amount of personal law. Now, prior to 21A is my first table. Everything is ISA. Let's kindly go a little slower. It's very important to remove these apprehensions. Everything in my first part of the table is ISA. ISA is supposed to be an agnostic, civic, secular law, which goes in tandem with this equally agnostic, civic, secular law like SMA. There is no Hindu, Muslim personal law involved. And the first part, even for Hindus, is a severance from the HUF. All the columns are ISA, 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 Muslim, Christian, everything. Now, after 21A, it remains the same, except for a Hindu couple. Well, I hope I'm clear on this. Except for a Hindu couple, the second part of my table is identical to the first part.
What you're saying.
Now, let's kindly go. Yes, therefore, take it slowly. I'm dealing with that. Petitioners submit that 21A does not create a barrier to a constitution-compliant reading, 21A only applies for marriages of two Hindus. Further, even when two Hindus marry under SMA, 21A links the SMA regime to personal law for only two narrow aspects. The whole case should go out of SMA because of this argument according to respondents. Succession and membership of HUF. Succession and HUF, that's all. So 21A is A limited to succession and HUF, second limited to two Hindus. Now, let us kindly come to my answers. I am respectfully submitting three possible interpretive answers. And your lordship, I am neutral to all. I have a personal choice. It doesn't matter. There are people here, other people. All three, according to me, it's a scare argument to say that so much big is happening, whereas these three, any one of them, of lordship's choice, answers it. Firstly, theoretically, this honorable court may elect not to pronounce on the applicability of 21A to non-heterosexual Hindu couples in the present litigation and leave questions of succession open for future litigation expressly. That's only option one. See option two. Secondly, in the alternative, the honorable court may hold that the SMA will apply to non-heterosexual couples exactly as applies to heterosexual couples. Today, your lordship has it applying to heterosexual couples. By virtue of the introduction of 21A, specifically, Hindu non-heterosexual couples will be governed by the HSA, just like Hindu heterosexual couples. But all non-Hindu, Christian, Muslim, will be governed by ISA. This is number two.
But to achieve this reading, now read what follows.
Yes, yes.
What do we have to do?
I have to. Is your lordship's shy of doing this minimalist interpretation? Will be the question. That's a valid judgment of your lordships. If I am asking for something which your lordship has never done before or is unknown to your lordship, is right. I submit this is a minimalist. See the next. Yes, next para. Next para. This is minimalist, is my submission. To achieve this reading, the honorable court may extend its gender neutral reading of the SMA to the HSA and the ISA. That's all the lordships do. Whatever it has to hold: one, widow and widower in the ISA, and male Hindu and female Hindu and widow and widower in the HSA shall be interpreted in a manner that is agnostic of gender and sexual orientation. That too, Malas, there are two options. By specifically saying personal law is out.
Really have to then recast or redraft the provisions of the Hindu Succession Act also.
No, your lordship, it doesn't have to recast it. Your lordship has to say, no, my lord is only in SMA. My lord is not going to HSA. My lord is saying either of two things.
You're saying that to achieve this reading,
yes,
this honorable court may extend its gender neutral reading of the SMA to the HSA and ISA. It may hold that the words widow, widower in the Indian Succession Act limited to issues of marriage and male Hindu, female Hindu, widow and widower in the Hindu Succession Act, again limited to issues of marriage, shall be interpreted in a manner that is agnostic of gender and
correct. Now, what does it mean? Give me a minute. It's very important. Give me a minute. It means that your lordships will first put a caveat at the beginning: we are not getting into personal laws. Second, cumulatively, your lordship would say that today all heterosexual couples are governed with 21A in only ISA, except for Hindu couples. So the large majority of non-Hindu couples are covered by ISA. Third. The
largest number of people.
No, that's the third. So I'm not avoiding it. I'm not avoiding it. I understand. My lord is right. Third, for the Hindu couples, the agnostic reading will be to words like male, female, widow, widower.
In other words, we are creating a new regime, essentially. There.
That may not be a new regime. That is even in,
no, it's not. If you drill down a little bit, the complication.
Yes.
Now, two spouses of the same sex, one dies. Now, who will that be? What is the kind of estate that she?
If your lordship adopts, may I read?
Well, then you see, when it comes to male, of course, it will be a son. He will be treated as a son. When it is a female, he will be treated as a daughter. Question is, what is that spouse? Will he be treated? Will that spouse be treated as husband?
When a male Hindu dies intestate, for the first priority is to the widow.
Yeah.
If it's a same-sex male couple and the male has died intestate, there'd be no widow.
No, but there will be,
So what you are now therefore
the
saying is that read widow.
reading that to be a compliant. He's the widow.
Substitute
The
another
surviving
word for the
spouse
word
is
widow.
Willy-nilly, we do enter into personal law.
Or,
See, this formulation has one.
surviving spouse.
No,
That's true.
See,
That's true.
it's a bit oversimplistic. Hindus, you say only Hindus. No problem. But at the same time, there is no problem when it comes to Indian Succession Act, where the Christians, it anyway applies to them.
No, I have no problem with
Then
ISA.
we come to the Muslims. Are the
21
one
is
who-
creating a problem.
Muslims are the one who are now bound by the ISA.
Yes. No, may I just...
Others.
No, may I just say, there's a third option I'm given. The problem is arising because of 21A, which takes you back. It is not arising for any other category. So Muslims and Christians who go under heterosexual couples under SMA go under ISA.
But Dr.
Now, the third one is...
Look at how that third, you are yourself struggling at an intellectual level. You say it is submitted that there is a third option. Yes. That this honorable court may hold that since religious and personal law related issues by agreement of parties are beyond the scope of...
That's what I started the matter with, Balas. We are saying outside.
We can't rule
No,
on...
but we started the matter
by saying that, look, by agreement of parties, this has been...
Forget agreement.
Create a minefield for a future bench.
Balas, forget the agreement. Your lordships is saying that from the inception, the petitioners... Balas, the petitioner... Kindly read the whole...
You have to then decide it.
No, Balas, kindly allow me. No. Well, kindly read the whole para. This matter started by the petitioners who invoked your lordship's court to say we don't want to get into personal laws. Your lordship can certainly rely on that petition. But now read the whole para. Just allow me. Third para. It is simply the third option. This honorable court may hold that since religious and personal law related issues, forget agreement of parties, I need to delete that word. I mean, I don't want to, not necessarily, are beyond the scope of this litigation, which your lordship declared at the beginning when the matter started. It follows that personal law statutes as well as provisions of secular laws that relate back to personal laws, that is only 21A, are excluded from consideration. Since 21A itself was introduced as an exception to the regime under 19 to 21, non-consideration of the issue would simply mean a reversion to the default regime of ISA.
So are we reading up or are we reading down by doing that?
Well,
Which of the two would it fall under?
Well, I am saying there are two options. Either it will all fall under ISA or your lordship may apply the spouse and person interpretation for HSA Hindus.
Then we come back to the old position that when it comes to same-sex couples, we will interpret it in a particular manner. When it comes to heterosexual couples, we will read all those laws in a different manner. Well, we will have to have those two different interpretive tools.
Well, so can I just summarize? After a preliminary statement that when the matter started, your lordship had made it clear and the petitioners have also said that there is no going into personal law, your lordship may adopt either of two. Allow me to summarize. One, that everybody is under ISA and 21A will not apply to the same. Alternatively, that everyone is under ISA because ISA is not posing a problem. But for same-sex Hindu couples, your lordship reads the word spouse or a word person. That's the summary of the whole thing. That much your lordship will have to do. If it is beyond the bounds of judicial writing, then it is beyond the bounds.
Should we include Hindu?
Please see the logic in my para 15. But I am saying this cannot be the complete exclusion which the respondents
Then there is a classification amongst the same-sex couples. You are saying that those who fall in 21A, you treat them differently, leave it at that. For the others, you have ISA.
No,
you are actually subclassifying now.
No, not in the second option. In the third option, yes. In the second option, the better option is whether your lordship interprets it to mean spouse or person. Then there is no such
Hindu
problem.
non-heterosexual couples would be governed exclusively by the ISA, according to you.
How is that possible?
On option 3, not on option 2. This is important. Let us forget option 3.
Then neither are we reading down, nor are we reading up, nor are we striking down 21A.
No, so let me leave aside option 3. Let us say that your lordship keeps 21A.
Dr. Singhvi, we are not writing a blog, we are writing a judgment for society.
Your lordship is keeping 21A. Let me tell your lordship how I would respectfully submit a judgment can be written with 21A existing. It will certainly not be a blog,
You may have that legislator's pen elsewhere. But you can't persuade us to use this here.
I can only make a submission. Well, it's how, let us just for a minute focus on 21A.
Yes.
Your lordships may adopt the second option. 21A is given full force if your lordship reads the word spouse and person. That's one sentence answer. Forget the third option. 21A is excluded, as my Lord Justice Bhat said, only in the third option. In second option, since 21A is there, your lordship applies it, but your lordship would have to do person or spouse that much of reading. That's the long and short of it. Now, is it such an insuperable thing that the whole case should be a mere declaration of marriage? Then there is virtually an empty shell. I would say it is only a cardiac checkup.
Or is it a transplant?
That too, cardiac checkup, that too by a physician, not a surgeon.
Ultimately,
Physician.
Court, please have a heart. That's what it is.
That's neatly put.
Let's just see the conclusion at para 15.
Yes.
Just see the conclusion at para 15. Because then I have these special categories coming after that. It would not follow from this approach. Now I am giving the answer to a possible objection to my approach. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Today,